monthly list, some private respondent without permission of the National Highways Authority constructed the liquor shop, my lord, in front of my private land, my lord. So they continue their
My lord, may I permitted to mention item number 9.
It's in the monthly list.
Yes. My lord, may I be allowed to mention?
Sir, item number 756 of the monthly list. My lord, there is an extreme urgency of the case because I am a whole lady of 7 years. And in 1998, the matter is going on between the state and myself. And the matter has gone up to curative petition. And my lord, my right has been established. Despite by the disadvantage of this. And despite that, they are not country copies. So kindly change their
My lord, may I allowed to mention the upgradation monthly list 971. This is urgency is not getting that permissions for raw materials, and this matter was heard by lordship, and it was urgent because adjourn this matter because of petitioner the state respondent was not present. Give the number. Let me see.
My lord, may I be allowed to mention one?
Non-prosecution. To be mentioned, non-prosecution.
My lord, may I be allowed to mention one monthly list matter 900. Urgency is that the appeal has been pending since 10 years. Last 10 years, appeal has no report has been found by urgency.
Appeal is pending.
Appeal, one appeal order has been passed, and they are not, ma'am. They are not doing any. They filed a report, madam, complaint authorities, and they are not doing expeditiously. They are not disposing the report that we have been allowed.
Give the number.
May I be permitted to mention item number 911, my lord. This is matter relating to a brick field. I was forced to stop the brick field for excess demand of non-payment of excess demand of royalty, my lord. Let it be up. Let it be urgent.
Item 700.
new motion, my lord, 22. 22, my lord, new motion.
22.
Yes, my lord.
How can 22 be new motion?
My lord, 2022, it's a new motion, my lord.
Give the number.
Item number 730.
Is that property only the judgment required to be supplied by the state. One of the matter is appearing in the common list.
Give
Item number 734, my lord. My lord, this is my petitioner before your lordship is a highest bidder, my lord. 1/3 of amount has been deposited. That is the amount 90 lakhs. But EC has been cancelled due to that the potential area is out of the potential area, my lord. But this is survey without survey report, my lord. They are issuing no tender, my lord.
Give the number.
Yes. 21 of your lordship's list in the monthly list, the artist is the matter pending March 2020. What happened in the meantime? It's land property. The property it has been allotted to someone else. When he transferred with the permission, but the petition is not being done. They are trying to take proceedings in this matter and trying to allot since they are not doing anything in the matter. Because of the non-petition, I cannot construct in the house because of the invitation of application is pending. But that is their initial.
Give the number. Give the number, please.
My lord, compensation.
Contempt application. Give the number.
My lord, compensation.
I think this is sufficient for a day.
My lord, may I be permitted to mention
compensation not paid, my lord, senior citizen, my lord, 1 year.
Wait for a couple of days. Well,
My lord,
I mentioned restoration application. Restoration. Give the number.
My lord,
Give the number. Give the.
may I be permitted to mention,
my lord, to matter ingress,
my lord,
legal construction ingress and egress has been stopped. I am applying for upgradation, my lord.
The entire monthly list is coming into the supplementary list.
My lord, one matter only.
my lord,
Only one matter.
may I be permitted to mention,
Wait for a few more days. Wait for a few more days. Come back next week. Rest of the matters,
My
please
lord.
come back next week. Please come back next week, madam. Yes. Maybe. Please come back next week. Yes, call the days list, please.
my lord,
Item 1. I think I have said what I have made it very clear. Please come back next week.
Item
Next
one,
week, days list,
My lord,
item number 1.
My lord, my indulgence, my lord. I'm praying for a adjournment today. Mr. Somudam is addressing your lordship.
The first matter,
This is the first matter. Item number 1, my lord.
you are appearing for the
I'm for
applicants,
the
petitioners.
petition. My lord, can it be accommodated on next Friday, my
So
lord?
this is along with the applications, isn't it? There's a review application also, I think.
There's
no?
a recall application, there's a content. These two are there.
On prayer of the applicants / petitioners, the matter is adjourned. Let the matter appear under the same heading on
On next Friday, my lord.
No, 21st, Lord.
14th, my lord.
No, 14th some matter fix, urgent matter fix before the
yes.
14th some urgent matter fix another court.
You
21st.
want a Friday?
Preferably, my lord.
No, not necessary.
So
Any day.
21st,
Ah, Lord.
21st July.
Grateful.
21st, my lord. Read your best.
item two,
My lord, I am for the petitioner. Your lordship's order has been complied. My lord, let the matter be disposed of.
Has been complied with. Good. It is submitted. It is submitted on behalf of the applicant and also appears from the affidavit of compliance that the order under contempt has been complied with. Paragraph in view of the same, comma, the contempt application being CPN such and such is
Complied with
disposed
the
of.
rest of the money আমি চাইছি।
Paragraph, there shall however be no order as to cause such and certified website copy.
Okay, rest of the money
item three,
Yes, my lord. I am for the contempt petitioner. On the last one, I was permitted to use my exception. I have served the copy on the state advocate.
Hearing.
On the last occasion, no advocate of the state appeared, but I contact to GP office. They told that the brief has handed over to Chonni Charan De and a served copy upon this item 3.
Yes. An exception has been used.
My lord, let me submit. My lord, after receiving the copy from him, I repeatedly searched him at Barasan 10, also at his telephone number. None of it is available. I could not get. Thereafter, I went to GP office. They told that Chonni Charan De has been interested for this matter. MK Ghosh is not here. They will better submit. How is that?
For the court in this matter and
I have served Chonni Charan De. See the order.
where is Mr. De?
And he accepted. Also, Chonni Charan De.
You are appearing in this matter, isn't it?
But now, kindly see, his telephone number is at 98308479. No, never.
Unnecessarily, we are spending time on nothing. Please hand over us an extra copy to him.
My lord, then I always serve upon the GP and on the internet book.
Difficult to give an extra copy to him.
Muskil. So then I have no extra copy now. I have not then serve. And my lord, I have another submission, my lord. From his affidavit, I find that the what order is being passed by Joint Secretary, DL and LR is not complying. So therefore, I may be permitted to serve another copy of this. My reply to DL and LRO, I may be permitted. He is also one of the respondent. May not be the alleged contempt, but he is the key person who will execute the deed of gift.
Can it be done in a contempt application, sir?
Yes.
It can be done.
My lord,
You can serve on someone who is not the contemptor at all.
no, my lord, here my submission is that from the annexure supported by him.
Exception, let him deal with it and come back.
Correct. नहीं कॉपी मुझे को दबा मम्मी
Learned counsel for the alleged
आपने
contempt.
दादा फोन नंबर दिन हमारे
that
ऑफिस
he
को
has not
देखो
received
ठीक है ना
a copy of the exception used by the
এই তো এই লিখে রুম 10 লিখে জানো তো
তার আগে কোনো exception
কে লিখেছে এটা
used by the
আপনারা চিনেন না এখন
petitioner
যেটা আপনি 11 করছেন এই ফোন নাম্বার ধরেন না টেলিফোন নাম্বার ঠিক আছে নাম্বারটা
against the affidavit of compliance submitted on behalf of the alleged contemptor is taken on record.
এখন কেটে 11 করছেন দেখো
Paragraph,
এই ফোন নাম্বার ঠিক আছে দেখুন
let the matter appear under the same heading on
আপনি দিমা ফোন ধরেননি আপনি তিনবার করে ফোন করেছি আপনাকে রিপ্লাই তো করবেন এবার ওনারা 40 জন দিয়েও কপি নিয়ে নিচ্ছে দেখুন আমি চন্ডিদার কাছ থেকে কালেক্ট করে নিয়েছি
1st August,
মানে ফার্স্ট ডিফিকাল্ট মানে 2 or 3rd August 2nd August
2nd August.
I'm grateful.
Item 4,
This is my content application, my lord. There's a direction for affidavit of compliance filed by the respondent.
Complied?
My lord, may I file an exception to this report because there is a direction for but the main contention of the petition is there is a filling of the garbage area which is for the cultivation of the petitioner, it's been damaged. So my lord, there is a reason order passed where it says we prayed for a compensation. In this order, it says compensation has been paid, but my client instruction is that compensation has not been received till date.
Where is your, you have filed your affidavit of compliance? The representation was directed to be considered.
Yes, my lord.
That has been done?
That has been done lately, my lord. Though lately,
Whatever, it
but
has
it
been
has been done.
So nothing further remains of
Nothing
this?
further remains, my lord.
If you are aggrieved, you have a
I can add
separate
to
cause of
separate
action. Yes.
cause of action.
Let this be disposed of in that case.
Yes, my lord, kindly
How will
direct-
your exception help you?
Yes, my lord. That's also true, my lord.
So let this be disposed of.
Dispose of, my lord. Separate writ will be filed against this.
Yes, yes. It appears from the affidavit of compliance that the order under contempt has been complied with. Paragraph in view of the same comma that the contempt application being CPN such and such is disposed of. Paragraph there shall however be no arrest cost as is certified website.
Great.
item 5,
May I please allot you a time for the petitioner?
I am for this state.
My lord, your lordship, earlier occasion I had sought for time, your lordship, for a filing exception to the report that being filed by my learned friend.
Yes.
My lord, my client intended not to file any exceptions and to hear out the applications on merit. My lord, if your lordship.
So therefore, my lord, this contention reflected in the affidavit is admitted.
Is it your
It's a
lordship?
false deed.
Is it your lordship? I have affirmed my applications wherein I have
he can make
specifically
his oral
stated.
submissions.
Yes, your lordship. My lord, petitioner before your lordship, as he has come before your lordship, challenging the action on the part of the state respondents in forcefully acquiring, taking possessions of the land of the petitioner who had purchased the land, his own land. He purchased it way back in the year 1952. Thereafter, he recorded the land in his own name. He was paying revenue. And one fine morning, sometimes in the year 2017, when this application was filed in the year 2017, he found that name of respondent number 7 has been recorded in the record of right. I was not informed, no notice was given to me, but subsequently when I came to learn, I just lodged objections before the respondents. At the time of hearing, respondent number 7 came and he said that the acquisitions of the land has been done way back in the year 70, somewhere around that, and possession was given to them. We specifically denied the very contentions of the respondents, and the respondents at the time of hearing, they failed to produce any scrap of paper, 7 except a certain document I will place before your lordship, my lord, wherein it was alleged that the acquisition was published in the gazetted notifications. But at the time of filing of this application, we frantically searched for the said notification, gazetted notifications, the book that was referred to, but nothing was there. We could not find such notification. And my lord, after your lordship, the coming advent of the new act, Acquisition Act, my lord, it is specifically stated in section 2424, subsection 2.
It is said that it was acquired sometime in 1958.
1958. But no documents, 7 except a map, 7 except a map, wherein it has been stated that it has been acquired, but nothing has been done. No other document has been shown. No order, the gazetted notification, what they have alleged out there, nothing was there. Even we couldn't search that. We couldn't search that. We couldn't find that. And after the advent, whatever it is, your lordship, it is admitted fact that we are in possession, we were in possession prior to filing of this application, that is 2017. We were in possessions. My name was recorded out there as the owner of the said land. I was in possessions, and it is admitted fact, your lordship, my learned friend failed to produce any documents with regard to notice served upon either me, myself, or to my erstwhile owner with regard to acquisitions, taking possessions, taking possessions of the said land, and making payment of consideration of compensation amount. Nothing was done. As per the new act, your lordship, I am either means prior to 5 years prior to advent of the new act, if the accusation, either the compensation was not paid,
Yes.
or the possession was not taken, or
24(2)
either
of the new act.
or
Yes.
either of the two, both of them. Out here, both. Neither the compensation was paid, neither the possessions of the said land was taken prior to advent of means 5 years advent of the new act. Lord, I am entitled to either two of it, either to claim my entire thing, my land, and or for the compensation at the present market rate. My lord, with this application, we have come before your lordship. My prayer, your lordship, I place the prayer first. A writ in the nature of mandamus, commanding the respondents to recall, cancel, or withdraw any order passed in respect of the land in question of the petitioner. A writ in the nature of mandamus, commanding the respondents, and specially to respondent number 7, to restore possessions of 0.93 acres of land to the petitioner in DUG number 1627 under Moza, Araipur, jail number this. A writ in the nature of mandamus, commanding the respondents to take appropriate legal steps against the respondent number 7 for making false representations before the state respondent in respect of the land in questions. And a further mandamus with regard to restorations of possession. And
Let us hear the state. Yes. Mr. Bhatt.
And
After all,
let me
he
place
has
it.
to prove that he has any title over the land.
Definitely, I will. Let me complete it, your lordship. With this prayer, your lordship, what I had submitted before your lordship, my right over the property. My lord, kindly turn to page 20, annexure P1, the first annexure to my application. This is a deed which is registered before the district registrar, district sub-registrar, Shivdi, this is Birbhum. It was registered on the date of registration is 17th of November 1952. My lord, initially the plot of land, the petitioner purchased 3 plots of land, 3 different plots of land, and subsequently it was amalgamated into 1 plot of land. We have specifically stated in paragraph, your lordship, at paragraph 5. We have stated that the petitioner states that the land was purchased, which was comprised in 3 plot numbers.
This is not your title deed. Where is your title deed?
This is my title. This is my deed, your lordship.
Acha, Sheikh Jansad.
Yes,
Acha.
yes. Initially, the plot, there are 3 plots.
So
3
you
plots,
claim to have purchased in 1952.
and subsequently, your lordship, my name was recorded on the next page, your lordship, page 25.
These are plot numbers 1151, 1173, and 1175.
My lord, one thing. 3 plots of land, it was subsequently amalgamated into 1, that is 1627.
Where is that document?
That is, I'm telling you, lordship, 1151, 1173, and 1175, measuring 0.93 acres,
Yes.
which was subsequently amalgamated as plot number 1627. And name of the petitioner was recorded as owner in respect of the aforesaid plot of land. My lord, this after amalgamation, your lordship, the record of rights shows at page 25. At plot number 1627, Bagan, 93 acres of land, 0.93, and it was recorded in the name of petitioner, Jamshed Ali, son of Suleiman Ali, at page 25. Lordship got it? At page
Yes.
25. And on the very next page, your Lordship, at page 26, which is annexure P3,
Yes.
petitioner has paid the revenue in respect of the said land.
When was the amalgamation done and why?
Where
Is the amalgamation of 3 plots?
Amalgamation is just long back. Long back. Just long back. I don't know the exact date, but it was done long back. Long back. And problem started only from the year 2017. And it is an admitted position. The state has admitted it. Hearing was done, hearing was concluded, and it was the specific finding of the state. Your Lordship, I'll take your Lordship to the finding of the respondent. The notice was given pursuant to my application, which is at page 29, annexure P5.
Yes.
প্রথম পক্ষের দখলীকৃত উপরুক্ত বিষয়ে এক লিখিত আবেদনের পরিপ্রেক্ষিতে নিম্নলিখিত আগামী ইংরেজি 11/10/2017 তারিখ বেলা 12 ঘটিকায় নিম্ন স্বাক্ষরকারী শুনানি গ্রহণ করিবে। উপরুক্ত শুনানিতে সংশ্লিষ্ট প্রথম ও দ্বিতীয় পক্ষগণকে তাহার বক্তব্যের সামর্থ্যে উপযুক্ত প্রমাণ সহ it's a notice. And thereafter hearing took place.
Yes.
The hearing starts from P6 at page 30.
And what is the concluding part of the order?
Yes,
Where is the
that I will be
concluding part?
going, definitely. But you are so hurry.
Wasting the time of
Unnecessary court's time.
wasting the time of court.
Yes.
This was actually a prayer for recording the
My
property
lord,
on it.
kindly the under, my lord,
Lord,
page
kindly,
35.
Lordship, kindly.
The
I will go, definitely. I will traverse. Yes, Your Lordship.
Kindly page 35, the concluding part of the order.
Yes.
Under the aforesaid observation, the claim of the petitioner to record the property in his favor is hereby rejected.
The court
But
cannot intervene in this matter.
Yes,
But please show me documents of acquisition.
my lord.
Documents of acquisition.
My lord,
My Lord, kindly, let me finish. Let me conclude.
Lord,
first. Let me
I
conclude.
think you have, let us hear the state because the state has to,
Yes,
has to say.
then my lord, kindly come, his document page, land acquisition proceeding, page 36. His document.
This is not my document. This is the only document they
You
have.
have annexed in your petition.
Definitely, I did it. I
Yes.
submitted before the court.
Yes,
This is a document of possession, not land acquisition.
my lord, kindly see the LA case number.
Yes, stop.
Yes, I would
Stop.
like to see the acquisition, the
Yes,
notifications.
yes, the LA, in that LA case number 1957-58, the possession has been taken. Now, if there, my lord, after more than 70 years. And secondly, my lord, kindly
What after
see-
70 years? What after-
58, After 50, how
What?
this record can be maintained?
Item number 2.
After 50 years, 30 years, you know that after 30 years, the record cannot be relied upon.
My Lord,
Yes,
they didn't take possession. Possession was with me.
Let me hear the state.
Now, my lord, kindly see my report in the form of affidavit. This deed is false deed.
Yes.
He preferred not to give any exception to that.
I have also annexed the
So what-
documents of the Milot sub-district
This is the-
sub-register
this is the
Nirbhu.
specific averment in
But
the,
how-
in the report.
how the
This is a
state-
false deed.
My Lord, how,
Challenged.
My lord, no,
Is it challenged?
my lord,
no,
can
never.
you see, this is the report and my lord, kindly see.
জজ সাহেব বলছেন ওনাকে চ্যালেঞ্জ করেছে
A 70 years old
Find
document,
any exception relating to the report.
a 70
I
years
also-
old
we had
document
admitted
merely
that.
by filing an
I have also
exception.
filed
it
an
will go.
opposition annexing the documents of the district sub register.
A 70 years old document, your lordship, merely by filing an objection or exception.
On
to
the
the
basis of
report,
false deed, his
No.
name was recorded wrongly and subsequently it has been found, my lord, the deed was not registered at all.
At all.
It's absolutely, my lord, frivolous application. And this was,
lord,
and my lord, not only that, my lord, this land was, my lord,
Yes.
mutated in the name of WBSCTCL authorities much
When?
earlier.
When?
That I have annexed the documents
Let them show.
in my opposition.
Let them show.
Yes, I have already filed.
Yes.
Report in the
my-
form of an affidavit.
In my report also, it is annexed.
In my report in the form of an affidavit, my lord, annexed chart, page 5, your lordship kindly see, the name of WBSCTCL is appearing, my lord, in the mutation record of it, my mutation and, my lord, thereafter my lord, the document showing that the districts have registered, my lord.
This is a 2017 document.
Yes. No. Yes, current documents we have annexed. This was, it was in the name of WBSCTCL.
You claim to have taken possession in 58.
Yes, that
So
we have
where is
not
the document?
already.
Where is the recording in your name in 58?
But now 58 documents, my lord, my largest page is not showing, my lord, that's why, my lord, I have annexed the mutation documents.
That proceeding, I was
58
forced to initiate the proceeding only for that, only for this wrong recording.
Whether in the deed court, my lord, this can be adjudicated.
Why
These
not?
are the total disputed question of fact.
Absolutely.
You forcefully raising a dispute will not debar.
Let him establish his right.
Go for the dispute.
Totally disputed question of
What
fact.
is it?
Totally disputed question of fact.
What is disputed questions of fact?
Total disputed. What is it means?
My lord, the report of the district register with whom?
Yes, I have annexed. Document.
What is this deed of 1981?
I'll tell your lordship.
Yes.
The deed of 1981.
Two deeds were executed. Initially in the year 1952, the same person executed the deed once again in 1981. And the wrong instructions.
That can
What?
be done.
Why not?
In respect
not?
of the same property?
Yes,
Same
same property.
How it can be
Same
done?
property. Why not? Why you can't be?
How, under what provision?
Under what
My
provisions
lord,
of
it's
law?
under wrong instructions
That
and
is
whatever
so
it is,
Wrong
whatever it is.
instruction, What provisions
But
of law?
merely
That is why it is
executing a
called-
subsequent deed in respect of the same property, my earlier document wouldn't go.
Yes.
It still remains.
How?
It still remains.
How?
Nothing to
How?
do with the earlier.
What is the necessity of execution of this deed?
You are claiming your title
On the basis of.
on the basis of the 1951 deed.
Yes.
The sub-registrar's report says that the deed was not registered at all in the office.
Yes.
Look into the document. It is there
So-
before your lordship.
Yes.
Look into the document, Annexure P1. This is the 1952 document.
Yes, that is false.
If the registrar says it was not.
Registered, my lord. I have
that
raised,
gives
I
a
had, I
different
wrote a
meaning
letter.
to the deed.
It is
Whether,
not correct
whether
document,
your lordship,
false document.
Whether-
How
Reference is correct.
how it can be adjudicated?
my lord, whether the registrar could raise any questions in respect of a deed that been executed 70 years back. I wrote a letter to him.
Because the
I wrote a letter.
subsequent-
The
My lord,
registrar can say whether it was registered
Yes.
at all.
Yes, they
Only
shall-
register can
Can you
say,
look into the document?
nobody else.
Your lordship has ample power to look into it, whether your lordship finds there is something wrong with it.
Is it the lead court?
Kindly
This court has no jurisdiction to find whether there is
Yes.
anything wrong with
Totally
it.
look into the
Totally,
document,
absolutely,
nothing
totally
else. Can you
disputed.
look into the document?
Question of fact.
Let him file.
What is the disputed questions of fact?
Since there's a dispute of title, this court cannot deal with the matter.
Madam, there is no questions of any
Grateful to you.
dispute. Let them show one thing. Let them show that the
Subsequent
land has
deed-
been,
Subsequent deed is.
land acquisition has been made by the state respondents.
Your
Everything
deed
will
is
go.
under challenge, sir.
Which one?
Your deed is under challenge. So this
Under
is a
where?
title dispute.
Who has challenged?
Where they
The
have challenged.
document
Lord,
says.
merely a document that's been written by a person. Your Lordship, maybe.
Person means he is the authority.
Definitely, I'm not denying that.
How my learned friend is saying?
I'm not denying that.
The read code can deal with this.
Yes,
It has to be relegated to the civil court.
Do that.
Absolutely.
This
That
is
will
a
be the correct order.
2017 matter. Ask them one thing,
He is the
ask them
authority.
that to show that, ask the state, my lord, to show that whether the land has been, any proceeding has been initiated for acquisitions or not.
That is
That is
allocation
all.
number is there.
That will
You
solve the
can
problem.
claim that only when you prove that you have purchased the property.
Yes, definitely, I have proved it.
The
The
deed
document-
itself, the primary document is under challenge, sir.
Yes.
But who
And
has,
prima facie it appears.
how the document has been challenged?
The district authority
a-
says. So the appropriate forum has to deal with this, not this.
Smile. Grateful to you.
My lord, one thing, I'll be relying on certain other documents also.
Done.
What other documents?
Can you look into this?
Which is
judgment
not in the
this one
part of the
report?
Are
report?
they part of your writ petition?
Are-
This document?
This is part of the writ petition? No, judgment. Oh, judgment.
My lord, I've specifically stated in one of my paragraph, your lordship, that at paragraph 16 of my application. Well, can you look into the judgment? Wherein if a person, a third party maybe, whose name is recorded in respect of a land, and he has paid rent in respect thereof, the state is not in a position to forcefully oust that particular person from the said land without initiating proceedings against the said person. That specifically, this judgment specifically deals with that part. And I have specifically a word also in my application.
What is the reference of the judgment?
This is Prafulla Kumar Shom versus State of West Bengal. And it was reported in 2002, 3 Calcutta High Court notes at page 13.
13.
13.
So we can
And this happens even the land is vested.
see.
Even the land is vested. And if a name of a particular person is wrongly recorded in respect of the said land, and he was revenue tax were taken from him, then even your lordship, the state is not in a position to oust that person from the said land without initiating proceeding.
Yeah, deed is false.
Initially, the single bench judgment of this honorable court of Panchu Mullah. versus state
Pachumulla has
of-
already been over.
But this is a division bench judgment.
Pachumulla has already
This
been
is,
over.
this is a division bench judgment.
That
sir.
has to be checked.
No,
on this.
75.
This is with regard to 14T3. This court doesn't have jurisdiction at all to
Determination,
consider.
yes.
it.
Not one thing, it's
43.
nothing to do with the determination.
I'm sorry, sir.
What
I
I-
have to
what I
relegate the matter
submitted-
to the civil court.
Yes, yes. Let him establish this.
Why to civil court?
Yes, civil court is the appropriate.
Why?
forum.
Because you are asking.
Merely, my lord, merely they have come forward with a piece of document.
Yeah.
Which is an
Really?
authentic document.
Ask
And
them
you
for,
have
ask them for the document.
And you
for-
have chosen not to use any exception to all these documents.
But it was all,
Because
I had
he has no,
my-
he has no.
Lord, in my
exception.
application, I have stated that.
What have you
False.
stated?
I've
Have you
stated
denied,
everything.
have you denied the authority of the district registrar? He is not an individual. He's an authority.
But
And
your
he
lordship,
states
that is,
that
if
he
that
was not
is, if
registered
that is
at
the
all.
authority, it's a point of law. I have taken, my lord, kindly, I have wrote a letter to him. This is
अरे लेटर दिए की हो?
That is not part
kindly,
of
your
the-
lordship.
That is not.
No, if your lordship pleases, then I'll be using an affidavit.
Ah.
Exception to the rule.
No.
Lord, can you look into this letter? Can you look into this?
What later will do?
Yes, definitely. If your letter can do everything, then my letter
No,
also
no,
can
this
do
is not,
something.
not my letter, not our letter. It's a government letter, authorities letter.
And his name in the section 50 proceeding, the authority has already rejected his prayer.
he has to go to the tribunal for selling that.
Yes.
He has not taken that remedy.
I have referred to in my said letter of section 81 of the Indian Registration Act. And there are provisions, Your Lordship, that if a person who uses a certificate, maybe a competent person, the veracity or legality of the said issuance of certificates could be challenged.
The report was on 7th November 2017, prior to the writ petition. And you have chosen to file
Your Lordship,
send a
that
letter.
that is subsequently I received from them the report that was filed by the learned respondent number 7. This is a report that's been filed by the respondent number 7 in 2023.
I'm afraid the writ court cannot deal with this issue at all.
Kindly not do.
Yes,
Ask them for the acquisition document.
not at
Simply,
all.
it will solve
You have to
everything.
first prove your case, sir.
Yes.
I have
Established
have
your-
proved
I'm
it.
sorry,
How-
I have to relegate the
What
matter. to the
more,
civil.
what more I have to do? The document is there. I had cited the
The
judgment
document
also.
is not an.
I cited the judgment also, wherein I have specifically stated.
It is not relevant to here in this case. It's a 14T3 judgment.
But
not
it
relevant
deals with
here.
the ownership of a person. It says that even if a vested land, a name of a person is recorded, rightly or wrongly, and if he pays taxes,
That part
Then-
has been decided already and you have not
By the
approached the
authority
appellate
under section
forum.
50. That part has been already.
It's a
decided
section
by
50
under-
order. You have not
how
approached the
could
appellate
the
forum.
state forcefully oust me from my own land?
The writ court cannot deal with it, sir. I'm sorry. You have to go before the civil court.
That's what you please.
The heard learned counsels for the practice. It is contended on behalf of the petitioner that the petitioner purchased the plot in question by virtue of a deed registered on 17th November 1952. And his name was recorded. It was accordingly recorded in the record of rights. Stop. Accordingly recorded in the record of rights. Stop.
Lord, may I take your lordship leave me, Lord? Great.
Sometime in the year 2017, the petitioner found that the name of the 7th respondent was recorded in the record of rights instead and place of his name. Stop. The petitioner approached the concerned authority for correction of record of rights, and in a proceeding drawn up under section 50 of the West Bengal Land Reforms Act, 1955, the concerned authority turned down the prayer of the petitioner on the ground that the plot in question was acquired vide special LA case number 57 of 1957-58. And possession certificate was issued in favor of the 7th respondent. In 1958. the petitioner has chosen not to challenge the said order. Paragraph. It appears from the report in the form of affidavit submitted on behalf of the seventh respondent that the deed of 1951, on the basis of which the petitioner claims title in respect of the property, was sent for authentication by the district sub-registrar, Birbhum, and the said authority, by a letter issued on 7th November 2017, stated that the said deed was not registered at the office of the district sub-registrar Birbhum, paragraph. Learned counsel for the respondents. Learned counsels for the respondents submit that since the title deed on the basis of which the petitioner claims right, title and interest in respect of the plotting question was not registered at the relevant sub-registry office and therefore is not a valid document, no relief can be granted to the petitioner.
My lord, one thing I'm submit.
In the
May I be
petition
excused, Your Lordship, my lord. Only one thing, Your Lordship.
on the basis of the said deed.
Subsequent deed, there's two deed. One deed just says it's good. That is, my title is there, so there is no dispute of the title, either on the basis of the earlier deed or the subsequent deed.
You have not relied upon the second deed at all
But it is there, they have relied.
in your writ petition.
Either way, Your Lordship, my ownership, as Your Lordship, what my learned friend has stated, there's a dispute of ownership. It is not. Whether through the earlier deed or the subsequent deed. They have either, when the officer concerned, Your Lordship, he has denied of my earlier deed, executions of the earlier deed, but she has said that the subsequent deed is good.
But your entire claim is on the basis of the earlier deed, 1981
It is,
deed.
but entire claim is not on the deed, Your Lordship.
Sir,
My
it is
lord,
your case.
my lord, entire case is not on my deed. My entire claim is on the land.
You derive your entire right from that deed.
My lord,
81
but whatever it is, but the title is not dispute. Either by the earlier documents or by subsequent documents. My
The
title
second
is
deed
there.
is only 1981.
Whatever it is.
So how do you?
So let them come up with the acquisition thing, whether that it has been acquired or not. There must be some documents. 7 except that document that they do not have it. They do not have any other document. At least let them ask for the document.
You have to first substantiate your own case.
I have substantiated.
Have
What
not,
more I have to substantiate?
Your writ petition doesn't contain this 1981 deed at all. How can you rely upon the report in that case?
Unnecessary system. Order
criminal contempt. Judgment বাধা দেওয়া criminal contempt.
Have to learn from me.
অধীনের প্রেক্ষিতে সেটাই তো
কি বললাম লাস্ট টাইমটা? Paragraph 4. Learned counsel for the 7th respondent has annexed a photocopy of a deed registered on 13th December 1981 in favor of the petitioner by the same vendor as in the earlier deed of 1951. This deed has not been relied upon or annexed by the petitioner in the writ petition. Stop. Also, no explanation has been put forth by the petitioner as to under what circumstance an identical deed was allegedly executed and registered in 1981 despite transfer of title in favor of the petitioner by the earlier deed executed in 1951. Stop. Paragraph, be that as it may, comma, since the title deed of 1951 is said to be invalid by the District Sub-Registrar Birbhum in his letter dated 7th November 2017, comma, this court is inclined to hold that there are complicated questions of fact involved in the writ petition, involved in this matter, which cannot be dealt with by this court in exercising jurisdiction under Article 226 of the Constitution. Paragraph, in view of the above, the writ petition being WP such and such is dismissed. Paragraph, it is made clear that this court has not gone into the merits of the case and the petitioner shall be at liberty to approach the appropriate forum for redressal of his grievance. Paragraph, there shall however be no response. ওইটা দিয়ে দেবেন, since no affidavit ওই chat line দিয়ে দিন।
Deeply aware, ma'am. Grateful.
Sorry, sir.
Yes.
Can't help.
By
Next.
later I have given.
You can take
Later what to take back.
Okay. That's good.
Item 6.
Well, item number 6, my lord, Mr. Parthopotim Rai was appearing on behalf of the petitioner. My lord, on the last occasion, your lordship had granted the petitioner liberty to use an exception to a report which was used by the state.
Yes.
My lord, I was
Cannot
seeking
take
for an extension, my lord.
The learned counsel for the petitioner seeks extension of time to use the exception as sought. Paragraph, let the matter appear under the same heading on 3rd August.
Mr. Bandyopadhyay is leading me, my lord. His legs in court number 8.
Item 7.
I am the state respondent, my lord.
Petitioner. Let it be not today. Though there is no resolution for the first half, still let it be not today. First half a resolution নেই কোনো আজকে
Item 8.
And for the petitioner, Your Lordship.
I am for the Union of India.
On the last day, there was a direction upon me to serve upon the NHI because no one is represented. I have served. They've received it on 3rd, Your Lordship.
Ms. Roy was here just now.
No, Ms. Roy is not.
She's not appearing. in this.
Someone else is engaged, Your Lordship.
NHI is the answering respondent.
Yes, NHI is required, Your Lordship, because this is the second round of litigation. If Your Lordship kindly take the first round of litigation order, page 50.
Give the money. So he is essential.
No, NHI is essential.
Doesn't choose to appear.
তুমি আছো আটে?
Ms. Roy, you're not appearing in this matter. May I regularize your appointment in that case?
The
May I
court
request you
can,
to appear?
the court can appoint you.
Yes. I'll regularize your appointment. Please serve a copy to her.
I'll send you.
So she's not ready today. She cannot be ready, in fact, today. So let her come back. Yes?
Your Lordship only praying for short date because every day there is a problem. The second round of
My lord,
litigation.
can fix on the Monday or Tuesday, madam. I think I will in the meantime.
I'll see. I'll fix a short.
Yes, earlier.
Serve her a copy.
Yes, sir.
None appears for the NHAI despite service of notice. Paragraph, Ms. Roy, who is present in court or appointment regularized court and copy service of direction. Paragraph, let the matter appear under the same heading on 20th July. 20th July, my lord, 20th 20.
20th July.
20th July.
Item 9.
Yes.
But I was praying, if your lordship will kindly not take it up today, give me a leave to file a supplementary affidavit annexing important documents so that your lordship can dispose of the matter.
Very well. You're appearing for the
For the statement.
My lord, I am appearing for the Howrah Improvement Trust led by Mr. Kollur.
Let it be adjourned. The petitioner wants to file a supplementary affidavit. On prayer of
This
the
is only
petitioner.
with regard to a short point of law that whether section 101 of Act 2013 will be applicable to the acts which has been committed under the Act of 1894. That is the. However, I am not in a position ever to say anything against when my learned senior friend.
No,
So
that's not it.
no
Let him
point.
come back with the supplementary.
Miller, absolutely.
On prayer of the petitioner, liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, let the matter appear under the same heading on 7th August.
2nd August. Your lordship. 7th.
Please serve an advance copy to the others.
Yes, certainly, my lord.
So that we can
Certainly.
take up the matter on the next.
Certainly, my lord.
Lord, my apologies that at various occasions I could not represent the court. My lord.
You must have been busy in other courts.
Milord,
That's
I-
perfectly all right.
Obliged, my lord.
10.
My lord, I appear on behalf of the petitioner. My lord, my senior is cannot come today because he is suffering senior eye problem. So not today, I pay for not today.
But several adjustments have been taken by
My
you,
lord,
sir.
on the last hours I pay again,
But
but
the state respondent.
unfortunately,
For the private respondent. Lord, on the last occasion, your lordship directed a matter to be listed along with this matter, Lord. Your lordship kindly see, look to the last order. That very read petition has not been annexed in this today's list. Your lordship kindly see that.
It's a 2014 petition, Mr. Rangan.
3182 of 2014 was to
So
be.
this court cannot deal with it. 2017 onwards, this court's determination. The petitioner has to get it assigned if he wants to.
My lord.
The petitioner can get it assigned. Otherwise, I do not have determination. Determination is from 2017. This is a 2014 writ petition. That's why it has not been tagged.
My lord, it was your lordship's order was there.
There was no, it is stated this court has no determination to deal with the same. So I cannot deal with the other repetition.
Short notes has been taken in my briefs, that's why I'm telling you.
It is clearly stated since the other writ petition was filed in 2014, this court has no determination to deal with the same. So let him come back.
Let him help.
Yes.
My lord, I have filed an application before the Chief Justice, my lord, for assignment.
Yes.
The Chief Justice and any assignment letter stated that you mentioned before her lordship.
How can that happen?
করতে হবে না,
I do not
আসুন।
have determination.
শোনো, জজ সাহেবের determination নেই।
The Chief Justice is the master of roster. He has to assign.
বুঝলে? ওনাকে assign করতে হবে, তুমি চিফ সেক্রেটারিকে গিয়ে বলো।
Please speak to the office of the Chief Justice.
I have guided him. I have guided him.
On prayer of- Yes.
Item number 8, my lord. I have been appointed, my lord. I have been appointed. I have filed the Pokaran also.
We are in 10.
Actually, when I just have.
8 orders.
I have filed the Pokaran. Pokaran has filed.
Please come on the next day. I have appointed Ms. Roy. Because you were not found.
She is standing, my lord. I have. If your lordship is.
This is very embarrassing for the court.
Yes, take one. Next week. Excuse.
Where is Ms. Roy? Is not here. Come back on the next date. I'll see. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 7th August. In the meantime, please see if you can get it assigned.
দেখে নাও, হ্যাঁ?
Master bless.
Item 11.
7ই আগস্ট। আমার সিনিয়র কি আছে?
May please allow.
To appear for the respondent numbers 1 to 5 led by Mr. Ashok Chakraborty.
Lord, this is with respect to, my lord, declaration of enemy property. Lord, your lordship had called for, my lord, a report in the form of an affidavit from, my lord, the state and the Union of India. My lord, kindly, my lord. Union of. But kindly takes up.
The Union of India has submitted a report.
Yes, my lord.
Both of them.
Yes, my lord.
Exception to file.
The exception, my lord, is also there.
Yes.
এটা কোনটা বলতো? এটা কোনটা?
এটা ওদের রিপোর্টটা দাদা।
না, দুটো রয়েছে।
হ্যাঁ, আমাদের এক্সেপশন এটা দাদা।
এটা কি করে?
সেম।
একই জিনিস, তাই দুবার দিয়েছিস? ঠিক আছে, দেখে নে একবার। আচ্ছা, আমাকে কয়টা পেজেস গুলো বল।
I can find the Union of India's report.
Now, the state pilot is really not interested.
File a report. No. Oh, it's
My
not the
lord,
Union.
we have
Wait.
filed a report, my lord, and
We have used an
taken
exception.
on record, my lord,
It has been taken.
my
Yes.
lord.
Yes, Mr.
My lord. Kindly turns to first pilot their impugn. Notice or, my lord, the impugned order. Kindly have a look at the public notice, which is at page
But
195.
there's a private respondent also.
I don't think so, my lord. আছে? কেন private respondent?
Who is it?
কমপ্লেনের বেসিসে এর কমপ্লেন
One Ankur Sharma.
ইস্যু করা হয়েছে।
My lord, there's somebody, my lord, who had complained with the, my lord, the Union of India, and on the basis of his complaint, my lord, that the Union, my lord, started, my lord, proceedings, and there was, my lord, a public notice. My lord, broadly speaking, my lord, these are properties at Tangra, my lord, which are owned by Chinese ethnic people, but they're Indians.
Have you served the private respondent?
Private respondent is service.
Where is the
Should be on
service?
সার্ভিস তো
Record any?
সার্ভিস তো রেকর্ড
Record এ থাকার কথা।
Because otherwise that becomes a ground for appeal. If he is not served.
সার্ভিস হলে না হলে কি করে হবে? But it's on
It's
record.
not on record. দিদি দেখুন তো একবার। আমার মনে হয় দেখতে পাচ্ছি না।
আমাদের জেরক্স কপি এটা।
না, ও
All the
পেয়েছে
stuff.
সেটা দেখেন।
হ্যাঁ, এই তো আইটেম ডেলিভার। এটা হচ্ছে ওই অঙ্কুশ শর্মা।
অঙ্কুশ শর্মা এটা কোথা থেকে পাবো?
এটা পোস্টাল ডিস্ট্রিক্টে পাবো দাদা।
নেই।
এই যে অঙ্কুশ শর্মা 358
দেখি অঙ্কুশ শর্মা আছে।
358 এই যে 358 item delivered.
রাখা উচিত। Affidavit of service. Affidavit of service. Is, Milord, your lordship looks at page 22. And initially, Milord, your lordship looks at the receipt is at page 9 and 22.
Yes, it's served. You
Served.
can continue, yes. Proceed, please.
Milord, kindly turns to Milord, page 195. This is a public notice, Milord, which is given on the right-hand side, Milord, of 195. Your lordship will find the general public is hereby, my lord, kindly found it,
Yes,
Lord, is hereby informed that there are 8 numbers of immovable enemy properties situated at 47 such and such road, erstwhile South Tangra Road. They are vested with the custodian of enemy property of India. These properties, being government properties, are transfer, sale of the said enemy properties are strictly prohibited and forbidden by law under statutory provisions of the Enemy Property Act 19 such and such. General public is therefore advised not to enter into any such transfer of property transactions, including apartment complexes, on aforesaid enemy properties. So this is basically, my lord, a declaration that these properties are enemy properties. Lord, kindly marks the word that this is a declaration. Now kindly looks to their, my lord, report. My lord will find that they have now started proceedings. I am not going to, my lord, trouble your lordship more. This itself, my lord, is one of the many grounds for it to be set aside immediately. কোথায় যেন বললো? Kindly turns to, my lord, page 12 onwards.
Page কত বললো?
15, 15.
Page 12.
115, my lord.
15.
Your lordship may look at page 12 also. It looks to, my lord, page 12. I have got no problem. It's better, my lord, that I place it before your lordship because it's from his own, my lord, report. I'll show, my lord, that this is premature. Let us say, paragraph 8, that it appears from the writ petition and the title report issued by Advocate Debojyoti Ghosh, most of the petitioners are lessee in respect of a huge volume or quantum of land, not riots. However, by dint of few alleged title deeds, few of the petitioners became riot for a minuscule volume, quantum of land in respect of 47 South Tangra. Irrespective of clauses or terms as mentioned in those alleged lease deeds, lessee will never become riot by any means whatsoever and shall not acquire any right as riot of a land. Further, nobody will be permitted to use, rather misuse any leasehold right while selling residential units as ownership basis as reported to this department as a freehold right, which leads to a gross violation of law. My lord, the enemy custodian has got no right, even no powers anywhere under the law to decide this. Anyways, these petitioners has no locus to file this instant writ application as the question of writ application does not lie at all. The alleged lessors, Chinese nationals and or their descendants, marks this, who were claiming to be owner or riot of the said land should have to file a petition. On perusal of few alleged lease deeds, it is clearly revealed that all share transferred by way of those alleged lease deeds are of undivided nature. Now claiming and establishing their own occupying portion of land as a specific demarcate area demarcated area cannot sustain in the eye of law after getting benefit of undivided share as leasehold right. As per law of partition, until and unless a property was partitioned by metes and bounds by a proper forum of law, no riot can claim the ownership for a demarcated portion of land, irrespective of their actual occupation. My lord, with a lot of respect to the learned gentleman who has affirmed the affidavit, my lord, he has forgotten the law, my lord, that if a co-sharer, my lord, has a right over every inch of the property if it is not, my lord, partitioned. So if it is not demarcated, my lord, I have a right over every inch of the property, not just the demarcated portion. And this is what he is acknowledging. No riot can claim any ownership for a demarcated portion of law irrespective of the actual occupation. 47 South Tangra is admittedly or undoubtedly an unpartitioned property, as the property has not yet been partitioned by metes and bounds. At the same time, having leasehold right, nobody is entitled to get any degree of partition either in preliminary form or in final form from any court of law. Present writ petition is not proper case to get a relief upon demarcation of land. Original alleged landowners or co-sharers of the land should have to file a partition case before proper forum of law for getting such degree. Further, the alleged amalgamation of plots with 47 is not at all tenable under the eye of law. Apart from the judicial authority, KMC has no power to amalgamate any plot or plots of land without partitioning the same by metes and bounds between all the co-sharers. A detailed spot inspection was conducted by the officials of this department. That I say it is pertinent to mention that the Commissioner or Deputy Commissioner of Kolkata Corporation has been vested upon to perform a vital and important role for the purpose of preservation and management of all the enemy properties situated under the jurisdiction of Kolkata Municipal Corporation, being the ex officio duty custodian of enemy property. This department made several attempts to get the map and revenue or survey records of 47 South Tangra from KMC authority along with important documents or records. Repeated letters were issued in this regard. It is also may be mentioned that except century-old CS records, latter RS or more recent LR survey were not done, or records are not available of the said area. So they don't even have documents to that effect. Now, that I say that it appears while perusing the main prayers, the petitioner has a grievance with the vesting, as most of the prayer is directly challenging the vesting. Petitioners have in prayer A, below the prayers have been below put out. My lord, may skip it over, my lord. That I say that it appears, paragraph 12, from both the prayers of the petitioner that they have challenged the vesting of the subject properties as well as vested enemy properties. In this context, I would further like to appraise you that the Honorable Court is not the forum of first instance for challenging the vesting of an enemy property, as an alternative statutory forum has been made available under Section 18 of the Enemy Law. I'll come to this Section 18. Provides an alternative forum wherein challenge to vesting of property may be done. Only after the central government passes an order under Section 18 of the Enemy Property Act, the High Court will have jurisdiction under Section 18C as amended in 2017, Wide Enemy Property Amendment and Validation Act 2017. That I say that the instant writ petition is premature, as the petitioner can only challenge the order passed by the central government under Section 18 as amended in 2017. Section 18C of the Enemy Property Act clearly provides that any person aggrieved by an order of the central government under Section 18 of this Act may, within a period of 60 days from the date of communication or receipt of the order, file an appeal to the High Court. Hence, the writ petition is premature, as the petitioner has to file a representation in the prescribed format before the Joint Secretary such and such in terms of 18 and section such and such are reproduced herein for convenience. Not 18 is reproduced, 18C is reproduced. I'll take your lordship to this later. The coordinated, my lord, then the division, some judgments have been, my lord, given. Then. That I say that the perusal of the title report as issued by the advocate Debojyoti Ghosh, relying upon which the project Laguna Bay progressed through all aspects till date, are vague and bad in law, as the petitioner number 16, who represented all the 15 members of the petitioner, being authorized signatories of them as the same person, who being advocate issued the said title report. As per Advocate Act, if an advocate is a full-time employee of an organization under any employer, he or she cannot carry on his or her practice. Title report issued as an advocate and signature of Debojyoti Ghosh being authorized representative of petitioner 1 to 15 is self-contradictory. Onus lies upon the petitioner to prove the same that these two characters are not related to each other, else title report may be set aside or license of advocate Ghosh may be terminated as per procedure of law. That I say that it was also reported to this office that those alleged lessors who are claiming to be Indian national presently residing at Canada are all Chinese nationals and or descendants of Chinese nationals. Nationality of these persons are doubtful, and accordingly an internal inquiry is about to begin by the competent authority based on such complaint. Kindly marks this statement, my lord. This itself shows that they haven't even, my lord, started, my lord, an investigation. And they have declared this, my lord, property to be an enemy property. I am on this, nothing further. Now kindly turn to, my lord, I will show from the title deeds itself. My lord, it's my writ petition is not premature, my lord. Their entire exercise is premature. Kindly turns to, my lord, page 49 first. My lord, kindly looks to the date. Made this 29th day of April 1970. This is a deed, my lord, between Monmoto Nath Khambri, son of late Trilokhonath Khamrui of 39B Christopher Road. My lord, these are all Tangra properties. And one part, Yao Li, Yao Lu Hung, Yao Li, my lord, the names are there. Purchasers. So, my lord, I am purchasing from an Indian national. There is no dispute about, my lord, Monmotho being Indian. There is no dispute. Huh? Yes. আমি সেটাতে আসছি, আমি আসছি সেটা আগে এগুলো দেখিনি আমি 48 এ আছি আচ্ছা very good.
These purchasers are your clients.
Yes,
The
from
petitioners.
it has come down from them from 1970. The list is given, my lord, at 48. Kindly see 48 once.
আর corresponding sale deed এর page আমি বলে দেবো।
CS Dag number, my lord, is 457 by 576. Dasbi Bata. This is deed of, this is the one which I was showing your lordship. 21st day of August 71, sub-registered Alipur, Maniklal Khara. Name of the purchasers, Li Yao Li and my lord, Li Yao Li, Li Yao Liang, Li Yao Hung. And 3 persons. And name of the predecessors in India of the vendor, my lord, is Uma Shashi Das. Then info for, my lord, this is corresponding to 49 and this goes to, my lord, the schedule.
49 is 29th April, the last one.
Yes, my lord. 29th of April, 1972.
The last
These
one.
were all Indian properties. They were all Indians. And there is nothing on record to show, my lord, that they are the Li Yaos are Chinese nationals. They don't even know.
63 তে date of vesting তখন এরা মালিক ছিল।
They don't even know. Why, my lord, they don't even know is because in 1963, when, my lord, the property was really, my lord, when there was a war with China, at that point of time, all the Indians were, my lord, the owners of the property in 63.
এক আর দ্বিতীয়ত এইটা দেখো রিপোর্টে
সেটা দেখিয়েছি।
এদের প্রপার্টিটা ওয়েস্ট হচ্ছে তো none of my
So this is, my lord, the initial, my lord, argument with respect to it being completely premature, my lord, to give a public notice saying, my lord, that these are enemy properties.
without demarcation.
When you yourself don't know whether these properties belong to China. Number one, my lord, all Chinese, because I am from a Chinese ethnicity doesn't mean, my lord, that I'm a Chinese national. Then, my lord, all properties will have to be, my lord, vested, my lord, with the
How do
government
you
of India.
connect the notice with your property? The
That's
notice doesn't
exactly what
have-
my problem is, because the notice is given on the entire 47. That is exactly what my problem is. My lord, if your lordship sees, my lord, my deeds and the deeds
Not
here.
the entire 47 also.
Kindly see.
8 numbers of immovable property is situated in 47.
Which one?
That's
May I ask this
exactly-
question to myself?
Yes.
Which ones?
And you are affected by the notice.
By that, I don't know which one. My lord, if my properties, let them say my properties are out.
The authority also doesn't seem to know. That's
That's my problem. They say that they don't know, but they have given below that these properties have been vested.
Page 5.
which properties are vested. The
That's
report also
exactly,
doesn't
that
say.
is exactly what
Does the
my,
report say
I'm
anything?
so grateful to your lordship. Comes to page 5 of the report. Kindly comes to page 5 of the report. Kindly turns to my lord. Page 4 first.
Because 8 properties are referred.
Yes, my lord.
So which
Yes.
are the properties?
And the 8 properties are probably, my lord, the ones at page 5 of the report. And kindly, my lord, takes that, my lord, with my lord, my documents.
Yes, my lord. My lord, what I beg to say before, submit before your lordship, my lord, we do not have any issue over the construction being raised over there. We don't, I mean to say, we do not have any issue with the petitioner so far as so far they are concerned. Admittedly, these are, as my learned friend has also said, this has not been marked in the vesting order. There has been a vesting order that is of 1963, my lord, and that vesting order says that the property at 47 Maheshwar Tala Road, that is that is a enemy that is a
Part of the
that is, it says that that vesting order of 1963 we have not annexed, my lord. I have for
8 plots. 8 plots.
8
in
plots,
the
and they
entire
have, yes, they have annexed it with the writ petition that 8 persons property of 8 persons, my lord. Those are the are enemy property under 47 that Tangra, Maheshwar Tala Road. Now, my lord, what I humbly beg to place before your lordship, my lord, we have no issue in deciding, but we are not the persons who can decide, my lord, because under section 18 of the Enemy Properties Act, my lord, that is to be representation has to be made before the central government, and we are also to be respondent over there. It's not that the custody that is to be made before the joint secretary of refugee freedom fighters.
Lord, if my learned senior friend says that my property, cut short করে দিচ্ছি, that if my learned senior friend says that my properties are not within this and she has no objection.
No, I'm not saying that, my lord. I'm not saying that. I'm not saying that, my lord. What I beg to place before your lordship, my lord, that there has been a vesting order which says that 8 properties in 47 Maheshwar Tala Road has been.
The details of those 8 properties.
Yes, that is not there, my lord. That may be a fault with the officers of 1963, my lord. But custodian is not. But my lord, custodian is not the person to decide that. What I humbly beg to place before your lordship, my lord, I will place before your lordship section 18, my lord. If they are after all, they are affected by good or bad by an order of vesting, my lord. Since an order of vesting has been passed, entailing all the properties, like it has named, my lord.
This is not an order of vesting.
This
Vesting
is
was
not
done long back.
in 1963.
Yes.
That is what I beg to say before
this
lordship.
notice was issued on?
Notice was issued just after it was raised, my lord, because we can only preserve.
February 2023.
My lord, we are the custodian is the is only they have the duty of preserving and managing enemy property, and we have done it in good faith, my lord, because we have to preserve and manage the enemy property.
Before you preserve and manage, you should know which is your property, which is
that is the problem, my lord. That is the problem, my lord. That is the entire 47. That is why, my lord, since it has not been demarcated, we have issued a notice admittedly with regard to the entire 47.
You have not. You have stated 8 plots.
8 plots, we have said that was in 2019. That also I beg to place before your lordship, my lord, that is of 2019. They have annexed with the writ petition. I did not want to take your lordship to that. They annexed with this writ petition that has been an update from the website that was in 2019. Now they were well aware of that fact that it is that undemarcated property, and it is a part of a property. It comes within a 47 Mohishatala Road, which has been said to be which is an undemarcated property, and 8 properties of which undivided property, undemarcated property of which comes within the ambit of enemy property. What I humbly beg to place before your lordship, my lord, we do not have any issue with the petitioner. Let them, my lord, let this writ petition be treated as representation before the Joint Secretary Freedom Fighters Rehabilitation Division, and kindly give us a time. We do not require more than 3 months to decide, because
What will you decide?
we cannot, it has to be decided, my lord, that whether that meets and means the demarcation has to be decided over there, my lord.
Not issue at all here.
What I have said, my lord, that we have to issue a no objection
They
certificate.
have only challenged this notice. This
Yes.
was issued by you. Without going into anything else, the notice is vague. You do not know on what properties you have issued the notice. You admit?
On 40, that is, my lord, that is what I beg to say, my lord. It was
Your notice would have
my lord, if
said
your lordship,
entire 47, it would have made some sense.
my lord, but
It
if your
says 8 properties in 47.
8
What are
properties,
the
but
8 properties?
we are not in a position to, since it
So
was
you are
the
not aware. In
1963.
other words, you are not aware.
Yes, my lord, admittedly, 1960, it was a 1963
Despite
vesting.
which we have issued this notice.
Yes, my lord, that because that we have done in good faith, my lord, because we are the enemy property custodian. So enemy property
How does
has
this
to be
work?
preserved, my lord. My lord, in sections, if your lordship kindly comes to, I'll take your lordship later on to section 18, my lord. And this is section 19, my lord, if your lordship kindly sees, my lord.
Do you have the book with you? Yes.
I apologize, I don't have the book. I apologize, my lord.
Thank you. Yes, please come to section 18.
Section 18, my lord, says the central government may, on receipt of a representation from a person, agree by an order vesting a property as enemy property in the custodian within a period of 30 days from the date of receipt of such order, or from the date of its publication in the official gazette, whichever is earlier, and after giving a reasonable opportunity of being heard, if it is of the opinion that enemy property vested in the custodian under this act and remaining with him was not an enemy property, it may be general or special order, direct the custodian that such property vested as enemy property in the custodian may be transferred to the person from whom such property was acquired and vested in the custodian. Now, my lord, if your lordship kindly
This
comes
is primarily a challenge to vesting.
my lord, and kindly, my lord, for once come to section 19, my lord.
Let's appeal.
Protection of action taken under the act. No suit, prosecution, or other legal proceeding shall be against the central government or the custodian or an inspector of enemy property for anything which is in good faith done or intended to be done under this act, my lord. Now, my lord, we are, as a custodian, since we do not know, my lord, it is undemarcated, absolutely, it is undemarcated. Since we are vested with, we are cast with the responsibility of preserving and managing the enemy property. And the 1963 vesting says that the 47 has been termed as vesting as an enemy property. My lord, in that regard, my then I'll have to place before your lordship the vesting order. It is undemarcated.
Vesting order is there. The 63 vesting order is there.
Vesting
but the
order,
properties are not stated there also.
that is what I beg to place before your lordship, my lord.
Let her come back.
I'm
sorry, I'm not convinced.
Because my lord, these
My entire
properties.
project is stalled.
I'll give you a
Entire
short-
project
I'll give
is
a short.
stalled. Because now, my lord, they don't know what they're doing. They just, my lord, then if my learned senior friends, my lord, submissions are to be taken, then every Chinese restaurant, my lord, has to be stopped. Every Chinese restaurant.
Difficulty is, if it would have been entire 47, would have made sense. Yes, the entire 47 is enemy property. No, you've said only 8 properties in 47.
That is what
47, there are several other plots.
My lord.
Properties.
My lord.
So they are not vested. And the petitioner
lord.
says that you have stopped their business in the plots which are not vested.
Because my lord,
It's
yes,
primarily there.
Let
It
them
is-
give
it
a
is-
notice
it is-
saying that
it is
the
our-
properties belonging to the petitioners, like this public notice, are not within their ambit.
No, we cannot say that, my lord.
That's what you have
We
said
cannot
today.
say that, my lord.
Today, my lord, there
Custodian
is
cannot
live
say that,
streaming.
my lord.
You cannot say that. How can you say this?
This.
We now, my lord, it was a 1963
Come back with
vesting.
documents showing the vested properties. I'll give you time.
Vested properties, I have seen that, my lord. I'm candid before your lordship, my lord. Since it's not on record, I cannot place it before your lordship. I've seen it, my lord. There is no demarcation.
Come
It
back with
only sees
supplementary affidavit, I'll
47,
allow you.
my lord.
If you come back with the vested properties, we can differentiate, we can
My lord,
distinguish.
if I'm not mistaken, if your lordship sees paragraph 5 once,
And section 18 is not applicable at all. here.
not at all.
Because this is
Kindly-
against an order of vesting. This is not
Exactly.
an order of vesting.
My lord,
It's
if
a
you-
notice declaring the vesting.
But my lord, subject to correction by your lordship, it's my very humble submission before your lordship. It is a continuation of that vesting order only. Because that vesting order was made, my lord, we had to issue this public notice, my lord, to safeguard this our means to preserve and manage the enemy property as a whole. Because the problem lies there, my lord, that it is not demarcated. What I was humbly proposing with all humility before your lordship, my lord, we don't have any issues with the petitioner, my lord, but the custodian cannot, when one is something has been termed as being an enemy property, we cannot just differentiate something from there and hand it over to them. So it is,
You have issued a notice.
that is we have to do, had to do, my lord. That had to be done because we could not demarcate, and we had to protect since 47 was mentioned over we had to protect the entire property. We will not, if your lordship, my lord, kindly directs, your lordship kindly keeps the matter pending, kindly direct, that will serve their purpose also. The joint secretary, freedom fighters rehabilitation, that is under
my property is not within the vesting area, but I will have to challenge the order of vesting. This is
no, I am
because,
not.
sir.
I am humbly
Will you please
placing.
come back with the specific properties which fall
My lord, if
within
I'm
your
not
vesting
mistaken, my lord, it's there at page 5 of the report.
of the report?
Of the report. And my learned senior friend was very candid in saying that she has found from the
Page 5 is only the vesting
these are the
orders.
these are the
There is
names
a
No, my
given.
lord,
Names given.
these are the names given, my
And we
lord.
do not come in any one of them.
These are the names given, my lord.
That's why she was candid enough to say.
That is why this is also my candid submission, my lord, that we cannot now demarcate it, and we are not in a position to demarcate it. So only because we have done it in good faith, my lord, that we had to preserve it.
Then you can't do it.
We have 8 properties are there. 8 properties we have taken, admittedly,
Entire.
8 properties, we have not taken that, my lord. Kindly appreciate, my lord. Kindly appreciate our duty under the act, my lord. It was 1963 and now we are in 2023. It was our predecessor in office that they have termed the entirety as the enemy property, be that as it may. 8 properties, they said that it is enemy property, but they have not demarcated. Our predecessors in office, they did not demarcate the 8 properties.
So can the petitioner be made to suffer for that?
No, should not suffer, my lord. But we are not entitled, my lord, to demarcate. We cannot now demarcate unless and until it is decided on evidence and all. We cannot demarcate like that.
Claim a certain property to be enemy property, then it is your duty to demarcate, which has not been done since 1963.
Yes, my lord.
You vest certain property and you do not demarcate. You do not know what is vested and what is not. Petitioner claims that their property is beyond that vesting.
My lord.
You have still issued a public notice which says that 8 properties. Petitioner should not be concerned with that at all.
So, my lord, that is our problem, that is our issue also, that is our problem also, that unless and until it is decided, we cannot now at this stage, my lord. Joint secretary, my lord, I will come.
At whose instance will it be decided? Petitioners are not part of that property.
My lord, kindly bear with me.
YouTube to record
My lord, I will place it before your lordship. Only kindly allow me to read it and I'm placing it. Order 3 of the my lord, transfer of property vested as enemy property in the custodian order 2015 says the concerned joint secretaries shall, on receipt of a representation from a person aggrieved by an order vesting a property as enemy property in the custodian referred to in paragraph 1, initiate process for giving hearing to the person from whom such property is acquired after giving at least 30 days notice to all concerned, including the custodian, requiring them to submit a reply, produce all documentary evidence and appear in person or through an authorized representative. My lord, what I have been instructed by my officers, my lord, that he is the competent person. We will also have to be a party respondent over there. Joint
Representation of a person who is aggrieved with the vesting. The petitioners are not aggrieved by with the vesting.
But because my lord, with all humility, I submit, my lord, because of that order of vesting, my lord, they are prejudiced.
They are actually not.
They are because of that order, and now
Prejudiced. They are prejudiced with your notice.
My lord, on this, my lord, I will come up with specific instruction that, but my lord, so far the act does not permit, my lord, asked to demarcate that, my lord. Because once the 47 has been vested, has been termed as vesting, allow me, my lord, to bring that vesting order.
I repeat, 47 is not vested. Only 8 properties in 47 is vested. There may be 80 properties there. We do not know. So you have to segregate.
Then in that even, my lord, we are not kindly, my lord, allow me to take us to this. Bear with me, my lord, kindly.
Petitioner's property is stated in the deed.
Yes, my lord.
Please show me that these properties are covered by your vesting.
Then, my lord, what I humbly pray before your lordship, my lord, I am just putting this. My eyesight is not working well, so I. This I'm putting on the mobile light, my lord. Josh, man, just put the word. See now. This is, my lord, 2020 I'm placing it before your lordship. 2010 notification, my lord, it says that in exercise of the powers conferred with section 3 of the Enemy Property Act 1963 and in suppression of notification such and such, the central government may hereby appoint the district magistrate, the district collector, as the case may be, the deputy commissioner of states of Andhra Pradesh, Assam, and somewhere West Bengal is also there. I'm really feeling pain in my eyesight to read so small letters. As the deputy custodian of enemy property for the areas falling within the territory of their respective districts. Now, my lord, here we have one in India, there is one custodian of enemy property. There are 3 branch offices. One is in Kolkata, one is at Lucknow, and another is probably in Bangalore. And now, my lord, here, for each district, we have an ex officio deputy custodian. My lord, he is possibly a party respondent also over here. Here, he is the commissioner of the Kolkata Municipal Corporation, my lord. Then, my lord, kindly direct him, because he is the ex officio deputy custodian, also the commissioner of Kolkata Municipal Corporation. And Kolkata Municipal Corporation, they have also played a role in this matter, in the matter of amalgamation of 2 plots, my lord. So kindly direct him, my lord. Kindly, it's a very small letter, my lord, but the commissioner here, we don't have deputy commissioner, we have the commissioner. Kindly direct them, my lord, to direct him, my lord, to decide.
I will grant you an opportunity to come back with a document showing the properties which are vested. A very simple, small issue. It's being much ado with without any.
My lord, but we'll require some time for that, my lord, because we'll find that at least.
Come back by the end of this month. End of this month. Come back by the end of this month.
My lord.
The specific properties, boundaries of properties which are vested. These 8 properties referred to in your notice.
My lord, but there are no boundaries, my lord. That is the sole difficulty.
So how do you refer to 8 properties? Your notice is vague.
I will come back. I will try to assist your lordship, my lord.
Meaningless otherwise, isn't it?
I will assist. I will assist your lordship to the best of my ability.
But the properties. So you cannot issue such a notice.
And I will assist your lordship on the point who is who is in that event, what is has to be done, my lord, because we are in we do not have that ability to, my lord, now demarcate those properties like that.
Lord, kindly grants an interim order, my lord, that this notice will not be, my lord, given effect to.
No, my lord,
Thank you.
kindly do not,
If
my
they
lord, because
cannot-
we have
if they
done.
cannot show your lordship,
If
my lord,
we-
the
that-
property.
we have
Let
taken
them come
2
back.
weeks time, my lord, no, my lord, that can
Answer
kindly,
for
my
But your
lord.
lordship does it.
That case, what will happen is if I give an interim order, the properties which are included will also.
Lord,
carry-
kindly takes up my lord's order.
I bow down, my lord.
Kindly have a look at your lordship's order of 24th. 24th of April. Kindly looks at it. My lord, kindly do not give them any further indulgence. Kindly do not. Kindly takes up, my lord, your lordship's order of 24th April.
Yes.
That on 24th of April, the
of the
matter came up.
properties.
My lord's order, my lord. Heard learned counsels for the parties, the notice dated such and such is sale in the writ petition. Learned counsel for respondent 1 to 5 seeks to submit a report in the form of an affidavit in this regard on the adjourned date. Let the matter appear under same heading such and such. The respondents are directed to indicate the boundaries of the properties referred to in the notice in the report. This is 24th April, so kindly do not give them any further, my lord, indulgence.
Then, my lord, all the properties will be will be
All the
attacked, my lord.
properties, yes.
There's a possibility
Eight.
of that, my
And
lord.
after that, the report has been filed.
My lord, we
So
are
if
saying-
they
we are-
don't
yeah.
know, they don't know. My lord, kindly do not, if they know, my lord, it will take them 1 day, 1 minute. If they don't know, my lord, they will go for end of the month and then say end of the year.
No, no.
Kindly
I
appreciate
will
this.
just grant them one more opportunity
Very
because I can understand the predicament of learned counsel also because
Yes, nowadays, my lord, everything is recorded. So whatever, my lord, my learned senior friend says, it's all there. So, my lord, we can, but yes, I understand her, my lord, and I completely, my lord,
just
Blood,
let us,
may I
let us.
kindly pray for this because my entire blood, this is a huge project, which has, my lord, come up to quite a few level. And now, my lord, when it's on the completion part, the bank is saying that I can't give you loan because of this public.
Wait for a few more days.
Give 7 days, my lord.
No, my lord, can't do it in 7 days. I'm candid before your
From
lordship.
April to, my lord, all this we are now in July.
Heaven will not fail on their head, my lord, till the end of this month.
2 weeks.
If they can wait, if my learned friend can
it's a
wait
do
for
or die
1 month.
আমার এ হলে, that is
20th.
20th.
20th, my lord. My lord.
Learned counsel for the respondent numbers 1 to, you're 1 to 5.
1 to
1
5.
to 5,
1
my
to
lord.
5.
Well, Kylie also records that none appears on behalf of the private respondent.
Yes.
Some
that was,
person somewhere, Milord, has just given a letter, maybe something, Milord, personal with the people there.
একদম শুরুতে করুন তো, none appears for the private respondent despite service. Paragraph, learned counsel for respondent numbers 1 to 5 candidly submits that since the entire plot number 47, comma, Maheshwar Tala Road has not been
Moteshwar
demarcated. Maheshwar Tala Road.
Moteshwar
Maheshwar Tala, road has not been demarcated and is a joint property, comma. The authority is not aware as to which of the 8 properties therein have been vested in 1963. Stop. Learned counsel seeks accommodation to take further instructions in this regard. Paragraph, let the matter appear under the same heading on 20th July.
20th.
20.
And Milord, may it be, Milord, by way of an affidavit. I think that should be, Milord, in a
Yes,
way of an affidavit so that they can take responsibility.
Seeks to,
Would it be my lord's pleasure also?
take instructions, ওখানে by way of an affidavit code.
It would be my lord's pleasure also, my lord, to record that it was also the submission of my learned senior friend that they had no objection with respect to our properties, our
No,
concern.
my lord, kindly do not record. I have.
CD আছে, YouTube এ আছে।
Mr. Chatterjee, let us not put her into more trouble. She's already in trouble. Let her come back.
Well, it's
Let her come back.
I'm not in trouble, my lord. My clients are in trouble.
You are representing your client.
Because I had spoken to my officers also that it should have
Here
been done.
you is not
It is-
personally you, is it? It's the
It's
clients.
always us. When I say I, Milord, it's always the client side.
Strategy, how is Justice strategy?
Very bad, very bad. I'm coming here only to keep my mind occupied,
Absolutely.
nothing. Very, very bad.
I can really feel what happens.
Deeply obliged, my lord.
12.
My lord, I am petitioner. Affidavit service is not complete, my lord.
Complete. You are appearing for?
Private respondent number 17.
So, and Mr. Day is for the state.
Yes.
So everyone is there. So it's complete.
There are some.
My lord, service is not complete. My lord, paying for time, my lord.
You are appearing for all the private respondents?
No, my lord, only respondent number 17. There are so many private respondents, but.
Let her come back. Since service upon all the private respondents is not complete, let the matter stand over till 7th August.
2nd August. Finish. My lord, in item number 13, appearing on behalf of the petitioner, my lord.
My lord, I am appearing for the state.
My lord, this is my affidavit of service, my lord. 2 private respondent is there, but they refuse to take this.
They refused. Very well, make your submission.
My lord, private respondent running their business by encroaching the public land. This is the Act of 62. My lord, given representation to the concerned authority, page 29, my lord. Come to page 29, my lord.
Yes.
So praying for removal of that illegal
Let this
encroachment.
be considered.
My lord?
Let this be considered.
Yes, my lord.
Yes, my lord.
The SDO.
Yes, my
My
lord.
lord, SDO is the authority under the public premises
Yes,
eviction
yes.
on authorization.
Affidavit of service. Paragraph, service upon the private respondents has returned with an endorsement refused, inverted comma, which amounts to due service. Stop. None appear, due service. Stop. Paragraph, none appears for the private respondents. Paragraph, it is contended on behalf of the petitioner that the private respondents have raised unauthorized construction by encroaching upon a portion of government land adjoining his property, comma, thereby obstructing his egress and ingress. The petitioner submitted a representation in this regard for the concerned authority on 7th June 2023, which is yet to be considered. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the third respondent
My lord, third respondent.
be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation dated such and such within 3 months
3 months, my lord.
from the date of communication of the order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. Disposed of, which actually.
My lord.
Rajkumar
Ten.
Singh.
14 Lordship, Jointu Dash is appearing for the petition. I am praying for a short pass over,
Not
Lordship.
possible, madam, in this court. I'm sorry. Please make your submission. Where is your affidavit of service?
Lordship,
Mr. Bandyopadhyay, you are appearing?
my affidavit of service.
Yes, please make your submission.
Uh,
What is the matter about?
Lordship, I am praying for implementation of the order, Lordship, passed by the DL and LRO, Lordship. My
PLLRO?
Yes, Lordship. It's page 34, Lordship.
Lord, I have got very innocuous matter. But I'm.
Allow her to, allow her to.
Yes, yes. It is page 34.
Lordship, initially, several RT applications made by the petitioner Lordship before the BLN LRO, but the BLN LRO have never considered those representations Lordship. That is why the petitioners have made application before the DLN LRO, including all, thereby annexing all the informations. After that, the DLN LRO have passed this impugned order Lordship. But after that, the petitioner have already made a detailed representation Lordship that is on page annexure P, page 36, P13 Lordship. But after page 36 Lordship P13.
Yes.
A detailed representation was made also, but that was also not considered by the BLN LRO Lordship. On that representation, we have also prayed for implementation of this order Lordship.
It is a response to a Right to Information Act petition, isn't it?
Lordship.
This is the first appeal.
Lordship.
So the proper forum is the second appeal? Mr. Bandyopadhyay?
Our prayer is, the DL and LRO has passed the order for implementation of his order to supply us the documents. 51A4, a suo motu proceeding was initiated against us without intimating anything.
You are referring to page 34.
My lord.
This is an appellate authority's order.
Appellate authority's
You
order.
are aggrieved, you have the
We are
proper
not,
forum.
I am not agreed. I am praying for implementation of this order only.
So that is
Nothing
also
else.
grievance. You can approach the authority.
No,
for
my lord,
implementation.
grievance is not, he has
The
been,
writ court will not direct implementation of an order of by the first appellate authority. Is it?
not the read court has the ample power to
Not
direct
everything
for
under the sun,
implementation
sir.
of the order, my lord. My lord, this order has been made in our favor. Only to, my lord, the direction, mere direction to comply with this order.
Yes, Mr. Bandyopadhyay.
That is the authority to my lord supply the documents.
Yes.
If it is permissible in law, otherwise, my lord, it's an applicable order.
It is permissible. It's very
It is
much
an
permissible.
appellate order.
It's an applicable order.
You have the second authority.
No, this is not appellable order, my lord. My lord, my humble submission is this. My lord, the order has been passed, but directing the BL and LRO to supply the document. That is the thing.
So you have to approach the authority saying that the BLLRO has not implemented.
Lord, the DLRO has no power to execute the order. No contempt application can be filed there.
No, contempt application cannot be filed.
Sir, this is very innocuous prayer. No, there is nothing. Thank you.
And your RTI is with regard to one section 51 proceeding under the Land Reforms Act?
Yes.
So this is again a specified act. So both ways this court cannot deal with it.
No, Milord, what is the observation? Kindly have a look. Milord, may I just place it? Whereas one Ramchandra Dalapati, village such and such, and have preferred for first appeal under section 19(1) of the RTI Act 2005 before this end on 22nd of February 2023
against inaction of block land and land reforms officer Narayangarh in connection with the petition dated such and such made before the BL and LRO Narayangarh. Whereas on verification of the case records and hearing of the instant appeal, it appears that he sought for information through 4 points queries on 11/4/2022 regarding status of the proceeding under section 51A4 suo motu of the WBLR Act 1955 hearing number such and such. And whereas in response to BL and LRO Narayangarh has replied him, he has replied through his office memo bearing number such and such stating that the desired miscase is not traceable, but the searching process is going on. Now, on perusal of the matter, I am of the opinion that such reply from BL and LRO Narayangarh is uncalled for which frustrates the spirit of RTI Act 2005. Hence, I do hereby direct to the BL and LRO Narayangarh to constitute a search team to trace out the case record and provide point-wise required information directly to the applicant in clear and clarified manner. If case record will not traceable in spite of intensive searching, then he will take necessary administrative measure in this regard under intimation to the appellant. A report on the status of action taken has to be submitted by the BL and LRO Narayangarh within 14 clear days from the date of communication of this order. But this is very innocuous order, and my prayer is before the read court, my lord, very innocuous prayer to direct the BL and LRO to comply with the order.
The
Nothing
matter
more, nothing.
pertains to the West Bengal Land Reforms Act.
My lord,
Yes.
so if I accept my lord's observation, my lord, then I have to approach the land tribunal.
For implementation.
My lord, this is not the appropriate forum. Land tribunal is not the appropriate forum for passing such direction.
This,
My
I
humble
don't know
submission
what is
is
your appropriate forum, but this is not the appropriate forum. I'm
Lord,
very
this is
sure.
my humble prayer. My lord, the read court has the ample power and my lord, the
Even
wide,
beyond the law,
my lord.
even beyond the law,
No, this is not beyond.
plenary powers are confined within the 4 corners of the law, isn't it? The West Bengal Land Reforms and Tenancy Tribunal Act specifically says that
I know.
a specified act cannot be dealt with by this.
My lord, if any appeal is preferred before the Land Reforms Act, before the DL and LRO, then I can prefer the the application before the land tribunal.
Anything pertaining to the Land Reforms
My
Act.
lord, my lord,
Yes,
my
if you
humble
have-
submission, my
If
lord.
you have the book with you, it is anything pertaining to the Land Reforms
My lord,
Act.
kindly take it up Monday. I will satisfy your
Very
lordship
well.
on this point.
Very well, not today.
My lord. No, kindly take it up Monday at the top. I will satisfy your lordship.
Not today.
Fifteen.
I beg to appear on the petition.
Well, I beg to appear on behalf of the KMDA being led by Mr. Navakumar Das. My lord, we just received the brief yesterday evening. We are awaiting for the instructions.
My lord, only my lord, very innocuous prayer to consider the representation.
You still need instructions?
My lord,
Instruction, we are yet to receive it.
very innocuous prayer. 2 representations are there, my lord. This is, my lord, with regard to, my lord, assignment and transfer of, my lord, leasehold right in favor of, my lord, third party. Before that, my lord, approval is required. My lord, 2 representations have been made by the intending lessee that kindly I got approval, but they have not given any reply. So my innocuous prayer, my lord, only to consider my representation.
What instructions do you need? Let the representation
Let
be
the
considered without going into merits. Mr. De, your where is your representation?
My lord, page, my lord, 39. This is the latest representation.
39.
Annexure P5.
KMDA. KMDA responded.
Affidavit of service. You've served the pro forma respondent.
He has received, my lord.
He was the erstwhile lessee.
He is the lessee, but not erstwhile. He is a lessee. And I am, yeah, an agreement has been entered.
Yeah,
Intending
propose,
purchase.
propose please.
Yes. Affidavit of service. Learned, the petitioners seek a direction upon the who should deal with the
It was represented before the secretary. That is my lord, respondent number 2, I think.
a direction upon the
Respondent number 2.
secretary, Kolkata Metropolitan Development Corporate Authority, comma, the second respondent herein, comma, to consider the representation submitted by them on 16 January 2023, requesting approval for assignment of leasehold right of the property in question for the residual period. Stop. Paragraph. Learned counsel for the petitioners submits that leasehold right of the property in question was granted to one Jitendra Lal Bhattacharya, and after his demise, comma, his son Jyotirmoy Bhattacharya inherited such right by virtue of a will executed by the erstwhile lessee. Stop. Jyotirmoy Bhattacharya intends to assign the leasehold right for the residual period of the lease in favor of the petitioners, for which the petitioners applied for approval before the concerned authority. Stop. Such representation is pending. Paragraph. Learned counsel for the KMDA submits that the second respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 1 month.
Within 1 month.
Within 1 month from the date of communication of this order, upon affording. KMDA says 1 month.
KMDA, why you are opposite?
My lord, make it 2 months, my lord.
1 month.
Weeks.
6 weeks.
6 weeks. Korun. 6 weeks. 6 weeks. Korun, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, comma, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph. In the event the representation is decided in favor of the petitioners, comma, consequential steps be taken by the authority within a month thereafter.
My lord, could it be 8 weeks, my lord? My lord, could it be?
6 weeks is sufficient only to consider approval.
Communication, then 6 weeks, then you'll get sufficient time. Disposed of the child.
More complicated issues are involved.
Absolutely. It's only approval.
Okay, my lord. Grateful.
I am good.
16.
My lord, I'm for the petitioner, my lord, services has not been completed, my lord.
Service not complete?
Not completed, my lord, I'm paying for not.
Since service upon the respondents is not complete,
For the Union of India, respondent number 7. Respondent number 3.
My lord,
so
My
they are
lord-
not appearing.
my lord, the pro forma respondent, my lord, Fairfax Industries, all services has not been completed, my lord.
Who is
I appear for the respondent Kolkata Port Trust.
Port Trust? Then you have the Holdia dock. Who are the other respondents who are appearing?
Respondent number 3.
Union of India.
For the custom authorities. Respondent number 3.
Customs authorities. Yes. So who is left?
My lord,
Holdia
Fairfax-
docks?
I think she is referring to respondent number 8.
And there are others also. It is a pro forma respondent. And my lord, all the services has not been completed, my lord. Everyone is appearing. Holdia. You are appearing for Holdia doc also?
Yes, yes.
Yes.
Portress.
So who is left, sir, madam? You are not ready. My lord, I got
I
instructions that.
think there is.
My lord, kindly make it not today. I got instructions that all services has not been completed, my lord. Kindly, my lord. On prayer of the petitioner, the matter is adjourned. Let the matter appear on prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 7th August. 7th.
Motions from monthly list. Item number 3.
My lord, but this is my application, my lord. On the last occasion, your lordship's desire to serve.
Who is appearing for the respondent?
My lord, Mr. Somraj Sen and Amitabh Datta. My lord, both on last 2 occasions, none appeared. None appeared for.
Your service of
Yes, my lord.
notice.
What happens, my lord? That day, Mr. Sen's clerk was personally present here. I told him that should I serve you? Well, no, doesn't require. I will inform my lord, if your lordship desire, kindly take not today. I will again serve him. Kindly take it on Monday, my lord, not today. Well, in spite of the notice, personally at the clerk, I told him. My lord, kindly pray for not today, my lord.
Please serve a written notice.
Of course, my lord, I will serve today. My lord, kindly take it on Monday.
The matter is adjourned. Monday?
Monday.
Let the matter appear under the same heading on Monday. 10th. 10th. না হলে বাতিল লিস্ট অর্ডার করতে হবে তো। হ্যাঁ অর্ডার হবে।
Item 4.
I am appearing on behalf of the petitioner, my lord. This is the affidavit of service. What are the several applications?
My lord, kindly see the last order of your lordship, my lord. State was directed to take instruction, my lord. The matter is.
Who is appearing? Who was appearing for this?
That was, my lord, old application for restoration.
The state was not represented at all.
No, my lord, on the last day, your lordship was pleased to direct the state to take instruction, my lord. None is appearing. Service, my lord, complete.
State wanted to take instructions in this matter, isn't it?
The state is not representing. That is the main whole difficulty, my lord.
On the last occasion, Mr. Ansar Mondol's
Was appearing, and your lordship was pleased
he
to.
was not appearing. His appointment was regularized because no one was appearing.
My lord may direct any person from state to appear in this matter. Otherwise, this third
The
round
same
of
direction
litigation,
was
my
given
lord.
on the earlier date. Same direction was given on the earlier date.
This is third round of litigation, my lord. Earlier, two direction was in favor of the petitioner. Even then, my lord.
That has been recorded also. And Mr. Mondal is not there today. So answer Mondal. Oh. So come back after some time.
As your lordship.
First week of August, he'll be back. Bad luck, madam, can't be helped. Affidavit of service. None appears for the state respondents. Paragraph, let the matter appear under the same heading on 3rd August.
Item 5.
Right. This is
Service.
yes. Everything is complete, my lord. 1 to 20, 5 to
Mr.
23.
Agarwal for
I am for 15, item number 15. 1-5.
The same
this is
point.
item 5.
Okay. There are all
Mr.
the
Agarwal for Metro Railways. It's very difficult. This is your supplementary affidavit.
yes. This
You
is my
wanted to use the
supplement.
supplementary.
Yes, this is my supplementary, my lord. I have stopped. My lord, a very short point is involved in this petition, my lord. What happened?
Today, let me not pass an order ex parte because
Yes, there is a
today
resolution.
it's an exceptional day. So,
So-
no resolution is after 2 p.m. But
Yes.
still, let it
But
be.
still, my lord,
yes.
but what I am praying before the lordship is this: will you lordship be kind enough to fix up any day and be placed in the supplementary list?
It will be. Affidavit of service and supplementary affidavit submitted on behalf of the petitioner are taken on record. Paragraph, none appears for the respondents. Paragraph, let the matter appear under the same heading on 28th July,
Little bit earlier, my lord, if it's
Um,
possible for you. lordship.
19th.
If the-
Supplementary list.
My lord, if you have listed us, supplement.
Next.
At number 6.
Same.
5 to 23. Same as a similar matter. 5 to 23.
5 to
23. 21. Sorry. 20.
5 to 21. Same order. Oh, it's with.
Yes.
No, 7, 8, 9, 10, alada 11 এর সাথে দিতে আছে সব।
My lord, I have not received the supplementary affidavit.
Yes.
I have not received the supplementary affidavit.
No. Sure, same
You are in
point involved.
15.
15-1-5.
50. You are appearing for the Metro Railways.
This is material.
He has to be served a copy of the supplementary. affidavit.
No, we have sub, all the parties are.
I have not received.
We have sought to give,
Show me the 15, item number 15, we have served, show me. Just a minute.
I am the educator. I have not received too many.
Oh, yes, my lord, he has served the railway, the department itself. This is my
Department is
affidavit,
served.
this is my affidavit of service. In any event,
Can you
my lord,
give me
I am
that?
handing over a copy
Yes,
of this.
please,
Give me
please.
copy, I will process.
Let a copy di dao.
To 21.
আলাদা আলাদা হবে 11 থেকে একই সেম অর্ডার। হ্যাঁ হ্যাঁ হ্যাঁ। যেভাবে আছে লিস্টে। I'm not calling till 21.
Supplement, all the supplementaries are with me. Should I file today or?
Say file it today. I'll record.
সবগুলোতে ফাইল করে দাও। প্রত্যেকটাতে ফাইল করে দাও পর পর।
Are you filing affidavit of service also?
Yes.
In all the matters?
Yes. ফাইল করে দাও।
Affidavit of service and supplementary.
সবগুলো দিন।
হ্যাঁ, পরপর করে দিচ্ছি।
ওকে দিয়ে দেন, ওরা সাজিয়ে নেবে, তুমি দিয়ে দাও, পরপর
শান্তনু?
সাজিয়ে দিয়ে দাও, ও দিয়ে নিয়ে করে নেবে।
ডাকুন একটা সুবিধা হবে, সুবিধা হবে। হ্যাঁ, it will be convenient if I call them.
Yes. কল করে তুমি
5 হয়ে গেছে। At number 6. হ্যাঁ।
Item number 7.
You are giving both?
Yes, both,
Yes.
both together.
Both the supplementary and affidavit.
Item number 8. Number 9.
As your lordship directed to annex that notification, where in the Act 30 or 2013 will apply in the Metro Railways Act, that I have annexed to you.
Number 11. Well, number 13. Number 14. Number 15.
My lord, I appear for the respondent, my lord.
In 15?
15. My lord, here, my lord, this act will not apply in this instant case itself. Right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement Act 2013, which they are, my lord, applying here and made application, my lord, for payment of interest under this act. And lord, this act will not apply at all because the Metro Railway Construction of Work Act 1978, the provisions already made there. In case of
I think it will be better if all the matters are dealt with together. It's the same issue in all the matters, I think.
Well, just one line of a document, I will show to your lordship. Then lordship can decide here and now that whether applicable supplementary.
All these matters are deal with the same issues.
my lord,
So
same issue, my lord. And last occasion, my lord,
They kindly have a look at this notification. I don't know how they can make these submissions.
Have
After
you received a copy
2015,
of the supplementary
Lord,
affidavit?
I have not been given, my lord, the supplementary
this is a
affidavit. which
gazette
they prayed for.
notification of them. This is a gazette notification of the Union of India.
My lord, copy has not been served to deal.
Copy has been served as
Yes.
the learned council has shown.
My lord,
It has been served to your department.
Lord, what happened, my lord, here, when the matter is allotted to the respective, my lord, the council, my lord, then, my lord, it becomes the duty of the council, my lord. It has not come to.
The moment this gazette notification 2015 come, my lord, 2015 Act, 2013 Act will apply, and based on that principle, my lord, my compensation has been assessed, and Metro has not paid for an appeal. They have accepted that. Now they are saying that it is actually not applied.
Let a copy of the supplementary affidavit, which has been, my lord, they are relying on, my lord. And
That exactly I have told you, Junior, that I will supply.
my lord,
He
the
has
copy,
said.
my lord, copy
So
be
please
served.
go through the affidavit and come.
Yes.
My lord.
Number 16. Number 17.
হ্যাঁ, খালি 15 এ appear করছে। ওখানে খালি এই লাইনটা বাদ দিয়ে দেবেন। এই যে এটা 15 এ appear করছে, আর কোথাও appear করছে না। খালি 15 এ লিখবেন না। ওটা 15 এর নাম্বার দিয়ে একটা লাইন করে দেবেন যে learned council, the respondents of WPA 11480 of 2020 are represented. WPA নাম্বারটা ঠিক করে।
Number 18. 19. 20. 21.
ওদের একটা কপি দিয়ে দেবে কিন্তু আজকে।
হ্যাঁ।
Number 22.
My lord, 22, I am for
It's a
the
time
private
of
respondent, my
regards.
lord, I am led by Mr. Monishin. My lord, I am praying for an adjournment, my lord, and he has not come to court.
You are for the petitioner?
So I am for the petitioner, lordship.
My lord, Ms. Monica Roy is also appearing for National Highway Authority, and my lord, she's engaged before other court, my lord, and I'm praying for not today on behalf.
On prayer of the private respondent and the NHAI, the matter is adjourned. Let the matter appear under the same heading on 7th August.
Number 23.
For the state. Well, there is a direction for affidavit. Affidavits are complete, my lord, as it appears from the record, my lord. Your lordship
Direction
may
for
fix the
affidavits?
matter in the hearing.
Instructions were sought to be taken.
Well, at the last,
No direction for affidavits.
as it appears from the brief, my lord, which I received, there are, my lord, the affidavits are complete.
But I do not find any direction. When was the direction given?
But I received the brief, my lord. Earlier, Mr. Dev was, my lord, engaged, but he has retired from the brief. Then I have been engaged, my lord.
Yes, yes, affidavit in opposition, yes, yes. So affidavits are complete. The reply is on record. The opposition,
Opposition, my, I have the only, my lord, copy, original copy is not with me. As it is
it's,
returned by Mr. Dev, my lord, then I have been engaged. ठीक है.
the brief has been handed over. So please find out because original is not here.
Original is not with me. শুনছি ফাইল হয়েছে কি? কোড ফাইল, কোটা ফাইল হয়েছে? কোটা ফাইল হয়েছে?
It has not been filed also.
But if it is not my file, then my lord, liberty be given to file my lord, reaffirm.
Please find out because I do not find it here.
But I have no.
If you have it, if the office has it, if your department has it, then you can file it on the next day.
কোটে ফাইল হয়েছে না ডিপার্টমেন্ট?
And the petitioner is also not there today.
It is filed in the court, my lord, as it's.
Petitioner, Mr. Mukherjee is
ফাইলে
appealing.
নেই, তাহলে আমরা reaffirm করতে হবে।
Where is?
Mr. Shoktinal Mukherjee perhaps.
Where is he?
The last question was there. The last question they appeared. And for the petitioner, madam.
Yes. The affidavit in opposition is not in the file.
Yes, my lord, on the day before the last date, my lord has a direction upon the then.
আমরা পেয়েছি, কপি পেয়েছি, মানে জজের ফাইলে
না, জজ সাহেব অর্ডার দিয়েছিলেন যে কপিটা ফাইল করার জন্য।
ফাইলটা আমাদের ফাইলে নেই, এটা রিটার্ন ব্রিফ হয়েছে তো।
My lord, I have the copy. Reaffirm করে দেন।
জজ সাহেব পারমিশন দেন তাহলে।
On the last day on occasion, my lord.
So, Mr. Bondapande, please come back with a copy on the next occasion. I'll accept it.
My lord, your lordship, my lord, give me liberty to file, my lord.
Yes, my lord has given, my lord has.
No,
Opposition.
that liberty has not
As it is not, my lord, in the file.
Day before the last
Without
date.
your order, my lord, I sir cannot.
My lord, can.
Shantanu,
Yeah.
দেখুন তো, file এর affidavit এর opposition টা দেখতে পাচ্ছি না। I'll just check.
না। দর্শক না বললাম করতে পারবো না। দর্শক ফাইলে নেই। Affidavit in opposition আছে?
না, নেই।
The reply is there.
Reply is there.
Opposition নেই।
নেই না? Affidavit in opposition used by the state respondents is not in the file. Paragraph on prayer of the state respondents, liberty is granted to affirm the affidavit in opposition afresh and file the same on the adjourned date. Paragraph, let the matter appear under the same heading on
My lord, any Thursday, my lord.
7th August.
7th August, my lord. Before than that, my lord.
He has to get ready.
Yes, 7th August.
Under the heading hearing. code.
Under the heading.
Hearing. Under the heading group 1 hearing.
Deep replacement.
করে নাও। করে আজকে ডেকে নাও, ডেকে নিয়ে করে নাও। দিয়ে এখন
Number 24.
My lord, item number 24, Mr. Supratim Dhar is appearing on behalf of the state respondent.
24. Yes. Petitioner. None appears for the petitioners. Let the matter appear under the same heading on 8th August.
24. Number 25.
25 Lordship, in this matter, I am appearing for the Lordship petitioner.
My lord, Ms. Monica Roy is appearing for the NHI authority, my lord. I'm just submitting the report, my lord, on the last occasion. She is engaged before the other court, my lord.
Have you've received a copy?
No.
Please serve a copy.
Yes, my lord.
Will you
I
go
have
through this
received.
and come back?
I have received the, yes, Lordship, I am to come, Lordship.
So you'll go through this and come back?
Yes, Lordship. Any short date, Lordship, because the land and the building of the petitioner, Lordship, was demolition without any acquisition proceedings. I have not get any compensation.
So it has been demolished, so no hurry. You'll get compensation. Report in the form of an affidavit submitted on behalf of the NHAI is taken on record. Paragraph, copy of the report is served upon learned counsel for the petitioner in court this day. Paragraph, on prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 8th August.
Yes.
Gratefully, lodge.
Exception? No.
Documents are in annex. I am relying. Grateful to Lordship.
Number 26.
26, my lord, I am praying for respondent, my lord, praying for not today, my lord.
Praying for
Not today, my lord.
And for the development of it.
petitioner? No one.
I am
Petitioner.
happy on behalf of the
Respondent.
petitioner.
Respondent praying for not today, my lord. Solely.
You are for respondent number?
All respondent, my lord.
All respondents?
All respondent, my lord. Solely, my lord.
All respondents.
All respondents?
No.
Auto respondent. Private respondent, my lord.
So you don't know for whom you are appearing,
Hello.
madam?
On behalf of Mr. Solil Maiti appearing in this matter, my lord. Another could engage, my lord. Not today, my lord.
Only not today.
No, not today.
Let it be adjourned, she's not ready.
If they, but the position is that there is a position of appeal, and the appellate authority is the district court, my lord. They did not prefer appeal, my lord.
What is the order?
Lordship, I am challenging the order passed by the
Page 70.
subdivisional magistrate.
Page 70,
Page number 70.
Unauthorized Occupants Act.
The order passed by the subdivisional magistrate is, as per the statute, states that
Eastern.
the statute said the order must be passed by the executive magistrate, not below the rank of district magistrate. State Highways Act.
No, Highways Act.
So this is appealable.
Applicable.
Applicable.
Do you have the book with the act? with you?
Highways Act, no, there is public occupant, unauthorized Occupants Act. Public unauthorized, my lord, part.
Appeal.
My lord, kindly see page 15. This is the second round of litigation. First round of litigation, the private respondent filed with petition, and Honorable Justice Yusuf got to pass this order. And page 15, bottom page, bottom portion. Yeah.
Didi? 1962 Act din tamake. Public premises unauthorized, eviction of unauthorized occupants. Achenjan.
There is a motion for appeal and district court is the appellate authority.
1962.
वो देखा ना जाकर
Highways Act अभी Highways Act
Highways Act तो
এখানে হবে।
Highways Act তিন to Highways Act endorsement.
সেম বই দুটো চলে এসছে।
এখানে আগের লিটিগেশন था
Public information.
হুম। 62 Act.
Appeal for district court. Appeal.
71 Act দুটো চলে এসছে।
section 9 बोले section 9
62 Act আছে।
Unauthorized encroachment within the state.
জায়গা করে নিতে ডব্লিউটি জায়গা ইনক্রোচ করে নিতে
সরে আমি দেখছি।
বাবার কাছে জেনে নিচ্ছি
Paragraph 3 to 4.
No, no, সরানো দেখছি।
অর্ডারটা আমি দেখেছি, অর্ডারটা ইভিকশন অর্ডারটা পড়েছি,
প্যারাগ্রাফ 3 দেখো।
প্যারাগ্রাফ 3 অর্ডারটা পড়েছি।
Do you have the book with you? It's an appealable order.
My lord, appealable order.
I would like to know the provision.
No, my
Uh,
lord.
No book.
দেখেছি অর্ডারটা।
But probably section 9, the provision of appeal.
That probably has to be made clear.
Uh, The copy, my lord, in mobile.
মোবাইল থেকে বার করে
দেখেছি এখানে। দেখুন আর একটা 71, তিনটে বই এসে গেছে 71। Public premises, West Bengal Public Premises Eviction of Unauthorized Occupants Act.
ডাউনলোড হচ্ছে। আমি পেয়েছি, ডাউনলোড হচ্ছে।
এটা দুটো ফেরত দিয়ে একটা 62 অ্যাক্ট নিয়ে আসতে
বার করছি, দেখুন।
এর আগে খালি ওয়েস্ট বেঙ্গল হবে। আর একটা আছে West Bengal Public Premises Eviction of Unauthorized Occupants Act 1962.
এই তো দিদি,
You found it only page in mobile. Section 9.
Public eviction,
The district judge of the district.
eviction of unauthorized occupant act 1963.
Yes, section 9.
Okay, Lordship, I will
So will you withdraw?
withdraw.
Yes.
Withdraw.
And I think you have crossed the limitation period.
Yes, Lord.
So I'll request the appellate authority to deal with it on merits. The order passed by the subdivisional magistrate, Holdia, on 22nd February 2022.
হাইওয়েজ একটাও যদি হতো, আমাকে তো সেই অ্যাপিল করতে তো ডিস্ট্রিক্ট ম্যাজিস্ট্রেটের।
District magistrate করতে হবে।
The order says this is under the West Bengal Highways Act.
No.
Order says state.
Please come to page 17.
ওটাই তো আমি বলছি।
In heading,
Yes.
but there is maybe miscommunication. But as per the order of
the order.
I have seen that, yes.
Order.
Is assailed in the writ petition. We did বললাম তো। The order passed on এত by the
অর্ডারটা তো বলা আছে স্টেট হাইওয়েজ অ্যাক্ট এর।
the writ petition,
স্টেট
huh.
হাইওয়েজ ওয়েস্ট বেঙ্গল
Paragraph. The order is amenable to appeal
কিন্তু
under section 9 of the West Bengal
বলা আছে
Public
তোমাকে তো অ্যাপিল
Premises
করতে হবে।
within bracket eviction of unauthorized occupants bracket closed Act 1962. Yes, yes. West Bengal public land premises now. Huh? Public land within bracket eviction of unauthorized occupants. 71 now. This is 62 Act.
62 to 7.
62 Act.
7.
Section 7.
Section 7.
To 7.
Oh, you showed me the 71 Act. No, this is 62 Act.
Yes, 7.
Under section 7. West Bengal public land within bracket eviction of unauthorized occupants, unauthorized occupants bracket closed Act 1962. Paragraph in view of the above. The petitioners seek to withdraw the petitioner. The petitioner seeks to withdraw the writ petition and approach the appropriate forum for redressal of his grievance. Paragraph in view of the above, the writ petition being WPS suggests such as dismissed for non-prosecution. Paragraph liberty is not paragraph হাত করুন আপনি paragraph পড়েন না এটাই একটা প্রবলেম আরেকটা কালকে Second, second correction, I guess. Second time. yes. Paragraph 4. Is liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, in the event the petitioner prefers the statutory appeal within 15 days.
15 days.
Paragraph, within 15 days from date, comma, the appellate authority shall deal with the appeal on merits without dismissing the same on the ground of maintainability, on the ground of limitation. Paragraph, there shall however be no orders to cover costs, urgency required. On the ground of limitation. Next.
27.
Thank you. No one, let that be their date today. I don't want to dismiss today. On none appears for the petitioners. Let the matter appear under the same heading on 8th August.
All of the petitioners.
Yes.
The statement of the presence of state advocate is necessary because the land not yet taken the possession by Mr. Oh, achi. But land acquired in 1990. The total acquired land 73 days. 25 the petitioners are the owners of the land. They did not, award was passed, but they did not give in a compensation. Then, I petitioners file an application before the landed additional district judge under section 30 for apportionment of that. The landed district additional district judge allowed my application and directed to pay compensation 2030. Before enactment of this new act, state not yet disbursed and not yet taken possession. Then the Fair Compensation Act will apply because as per the judgment delivered by the Honorable Supreme Court. If the state says that there is no necessity of the land, release the land. My residential building is there in that land. He submitted a report regarding releasing of the land. Page 48, kindly see the order passed by the landed additional district judge, LA Tribunal, page 48. But the prayer for apportionment of compensation such and is allowed in terms of the joint petition dated such and let the petition be part of the award. 48.
Service to the where is the application in connection with this? I want to see the names of the parties.
In an additional district judge.
Section 30 application.
Section 30 application.
Because the parties are not named here in the order.
Section 30 petition touch in the file. The additional district judge file. I will. No, that's not. Tell him to another time here. তোমার ছাপ ওনার এটা কি আছে তোমার ছাপ প্রথম আছে তো আমাদের
Who were the opposite parties in the petition?
Yes, my lord. The petition Nirmal Kumar Saha and others is the plaintiff. And LA collector is page 43. Nirmal Kumar Saha is other to 73. I being the owner of 20, petitioners are owners 25. Page 43, Nirmal Kumar Saha and others. Plaintiff. More kindly LA case number 24/01. And notice, kindly see the
So
notice.
apportionment between Nirmal Kumar Shah and your clients.
And
Yes, Mr. Bandyopadhyay.
Take instruction, my lord.
Take instructions. Let him come back with
Yes, yes.
instructions.
But not yet taken possession, still since 90.
Take instruction again, again.
Because there's an order of apportionment also.
My lord.
Heard learned counsels for the parties.
Service time.
Learned counsel for the state respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 8th August.
Affidavit of service only kept there.
Through the affidavit of service.
কবে আসবে এটা আবার? 8th August.
29.
Lordship, I am appearing for the petitioners on the last occasion. This is a petition against the metro authorities, your lordship. On the last occasion, your lordship gave direction to the metro authorities to submit a report. We have not
Appearing for the metro authority.
last occasion, your lordship, senior advocate Bikash Ranjan Bhattacharya addressed your lordship.
Today I do not find anyone. Will you come back some other day?
As your lordship pleases.
None appears for the respondents. Let the matter appear under the same heading on 8th August.
And I appear for the petition, my lord. This is my affidavit of service.
Respondents,
Respondents, my lord. Last occasion, my lord, petitioner did not appear, my lord. It was adjourned, my lord.
petitioner did not appear.
But here, my lord, that
You're taking turns not to appear.
here, my lord, one notice has been issued by the Control of Highways Act, my lord, page 49, my lord, for removal of an unauthorized construction, my lord.
The NHAI and the state.
My lord, I have served, my lord. But this property belongs to mine, my lord. I have raised an objection under section 23 of the act, my lord, page 50, my lord. That has not been disposed of till date, my lord. I have got the, my lord, deed as well as the record of right, everything, my lord. I have annexed, my lord.
Where is the service on the state?
My state is not party, Union of India, my lord.
The last respondent?
Project National Highways. And DM is the
Land acquisition collector?
my lord,
Please serve.
may I just check
Fourth
up?
respondent.
May I just check up? May I just check up, my lord?
I do not find it. এটা দিয়ে দিন তো।
একটু দিন। National Highways. No, no, it has not been served.
Servant. Since affidavit নিয়ে নি দুজনের সার্ভিস আছে affidavit of service নিয়ে since service upon the state is not complete, let the matter stand over till 9th August.
That matter by 1 week, my lord.
1st August. So, right. State.
Good.
Actually, on the 9th, 1st.
31. Item number 31, Ms. Roy is appearing for the NHI authority, my lord. I'm praying for not today.
But I'm for the petitioner, my lord. I have no objection, my lord. The national highways land was acquired that initially the compensation was not paid, my lord, we challenge this order before your lordship, my lord. Your lordship that is to consider our representation. This is that was not considered within time, file content application. When that during pendency of the content application, that the competent of the passed order, I've challenged that order. They also can't fix any.
So let her come back.
Yes.
If you want to take instructions, please take that in the meantime. Okay?
Yes, your lordship. Grateful, your
On
lordship.
prayer of the National Highway Authority of India, state is also not there.
State initial
Mr.
matter,
Banerjee,
initial minister, they was appeared.
Find Mr. Owen Banerjee's name. None appears.
Oh,
for the
yes,
state
yes, Warren Banerjee. Oh, he
Then none appears for the state respondents. Therefore, on prayer of the National Highways Authority of India, the matter is adjourned. Paragraph, let the matter appear under the same heading on 8th August.
10th August.
8th. 8th August. 8th August.
8th August. এই আমার নামটা দিয়ে দিও।
তাপস ভট্টাচার্য।
Yes. ভুলে যদি যেতে না।
One and only তাপস ভট্টাচার্য।
যদি